what does that mean to your case?
Justice Mantlantla, I'm not quite sure. You say, if you find against me. But the moment you find that the power to make the request is a power vested in the NPA, then that is a power, then that's a finding in our favor and goes against the SCA judgment in Schultz. If you were to find, however, that we are mistaken, that the power to make the request does not vest in the NPA, well, then we lose on that first of our points. But there remains the other 2 points. The first is that there was a valid US court order. And the third is that the Abraham principle is in any event not triggered because it was a good faith error.
Can we say that there is a portion of some duty or obligation or authority, certain things that have to be done by the NPA? Because the NPA is the one that decides whether or not to prosecute. So one has to accept that the NPA has a duty. And then the other part, when the NPA submits the documentation to the department, what are we saying about that? Is that part of that power or what? What is it?
Justice Mtlantla, in our case, that issue was never explored or investigated at all. The fundamental issue in our case is who has the power to make the request. The High Court, following Schultz, said the power vests in the Minister of Justice and therefore our request was unlawful. We submitted it was mistaken. The power vests in the hands of the NPA and therefore the High Court judgment should be overturned. But exactly whether the Department of Justice should play a role and is required to play a role, and exactly what that role is, was simply not explored in the Chilota case. It might have been explored elsewhere, but not there.
Thank you, Mr. Chair.
Thank you, Mr. Trengrove. I just want to explore a few points with you, please. And the first one is that the distinction between the role of the NPA and that of the minister, whether it's the Minister of Justice or the Minister of DIRCO, is something that also arises sharply in the judgment of the SCA, in Schultz. You're not involved in that, but you in a sense, spoke to that in support of your first point. And what the SCA says is that while the minister has the power to decide whether to make an outgoing extradition request, he cannot do so in a manner that undermines prosecutorial independence. Whether he has acted within the realms of his authority will depend on the circumstances of the extradition request in question in any given case. I'm just grappling with that, precisely what it means. It sounds a nice balance. But let's assume the NPA submits a properly motivated request with the evidence, everything all in place. And the minister, yes, sorry, maybe I was too far from the mic, thank you. And the minister looks at it and the minister is satisfied on the merits that this is a good request. However, at the time, South Africa is negotiating a prisoner swap agreement to have South Africans who are held in the prison of the country in question return to South Africa. And the minister's counterpart in that country says, well, look, this is a very delicate stage in these negotiations. If this request comes through from your side, we are unlikely to proceed with the prisoner swap agreement. Now, my question is that different considerations would apply to the NPA when it exercises its prosecutorial authority and independence. And given your acceptance that at the international level, different considerations apply there in terms of how South Africa discharges its foreign relations with other countries. And when those two come into conflict with each other, for example, which potentially could be the case in the example I've given you, how does prosecutorial independence, in a sense, win at the end of the day? If the minister may well, or if you say, well, under those circumstances, the minister is obliged to send that request through.
Yeah. Well, let me say this. Firstly, we submit unequivocally and unambiguously that the power to seek a request vests in the NPA and only in the NPA. It doesn't require anybody else's permission to make such a request. I'm not sure that the Minister of Justice has a role to play at all. The Minister of Justice is a political functionary, and it seems incongruous that she should play a role at all. What I certainly say from a constitutional perspective, that it would be unconstitutional to subject the NPA's decision to request extradition subject to a veto by the Minister of Justice. That would be unconstitutional. The only question is, how do we observe the niceties of international diplomatic relations? That function is performed not by the Minister of Justice. He's not our diplomat. Our diplomat is Durko. And I accept that those requests made by the NPA has to be channeled through diplomatic channels. Exactly how those channels work and whether the whether Durko has any residual power to refuse to pass on such a request is also an unexplored question. And I accept that it may give rise to a debate. But I submit with respect that the Minister of Justice does not have any power to impinge upon the power of the NPA to request extradition. And that was the issue in this case, and in Schultz.
Thank you. My second point, Mr. Trengrove, is whether in your third point, with regard to if we're not with you on the first two, Section 172 has any role to play. And I ask in this context, the SCA interpreted the Extradition Act in Schultz. In doing so, it located the exercise of interpretation within the heart of the Constitution, because they said the question of interpretation here rubs up against the principle of the rule of law. And it was really that principle that lent itself ultimately to the interpretation it arrived at. So one could argue that what is before this court, or certainly now, is a constitutional matter, because it involves the interpretation of the Extradition Act. And 172 says that a court may then provide a just and equitable remedy. And that doesn't only relate to declarations of invalidity, but it would relate to conduct that is unconstitutional. And the declarator of the SCA would have the effect that if the power vests in the minister only, then if the power is exercised at any time outside of how we frame that power, that would be unconstitutional. And arising out of that, my question is whether 172 has relevance, and whether it has relevance within the doctrine of objective constitutional invalidity. Because that doctrine proceeds from the basis that if court finds that conduct is invalid, then in the case of this piece of legislation, it would find that from the date of inception of the legislation. And what the SCA did in Schultz was not to deal with the question of retrospectivity, but the default position would have been that retrospectivity would have applied. And then just to complete that, the court in Chilota embraced Schultz, but it applied Schultz retrospectively, because the decision in Schultz was in 2024. And the request in Chilota was in 2022. So at the time the request was made in Chilota, Schultz hadn't been decided. And when the court applied Schultz, it would have had to do so retrospectively. And so in that context, I ask whether 172 is relevant here, and whether on the question of retrospectivity, that certainly, in my view, would continue to raise a constitutional issue.
Well, Let me just say, I'm acutely aware of the fact that the retrospective operation of Schultz is a hot issue in the Schultz appeal, so I'll try not to tread on their toes. But our submission is, if one were to take it back as you did, to get to your question, one firstly postulates that the power to make the request vested not in the NPA but in the Minister of Justice. Therefore, there was no valid request. Then the question still is, why does that invalidate a US court order? And how does that entitle a South African court to reassess a US court order on its merits? So we submit with respect that that is where the inquiry will in any event stop. But let me accept.
I just interrupt you there. Let's assume that the request was bad in law from the inception because it was made by the wrong functionary. So would that not mean that how it came to land before a US court would have been tainted from the beginning?
The question of whether the validity of the US judgment depends on US law. And we have no idea what US law requires for an extradition. We submit in any event, even if US law, for some unknown reason, required the request to come from one South African functionary and not from another South African functionary, then the remedy of Mr. Lota lays there. Our courts do not have the power to sit in judgment on the merits of a US court order under US law. But let me, because I understand your question also to ask me to postulate that you find against me on that issue. Then the question is, if this court were to find that the US court order, that the request should have been made by the Minister of Justice, for that reason that the US court order is invalid, what then? And you suggest that 172 might then kick in. Let me just say that that may be so, and I would have to give it a moment's thought. But the principle adopted by Ibrahim and by the English cases that follow it is that our courts have an inherent power to protect their processes against abuse of process. So there is a recognized power vested in the courts to protect itself against the abuse of its process. So one doesn't need to go via Section 172 in order to get there. Whether one might invoke Section 172, I suppose one might do so by, if you hold that the US court order is invalid because the request for the order, South African request, was unconstitutional, then you might find that the request was unconstitutional and then regulate the implications of that request under Section 172. That would just be a just and equitable discretion, and all the same considerations that I mentioned would come into play. It might just be unnecessary to go via the 172 route.
Just my last question. Let's assume that we're with you that the High Court may have erred on the question of the source of the request, and on that basis we're with you. Where does it leave us in terms of how we dispose of this case? Because what would have happened is the High Court did not make any findings with regard to the special plea as contained in the written special plea. And
well then,
said it wouldn't. So would it have to go back, or would this court have to decide that as a court of first and last instance?
No, I'm not inviting the court or suggesting that the court should decide the merits of the special plea. The High Court picked this one point and upheld the merits of that plea on this one point. If you find that it was mistaken on that point, then the issue must go back to the High Court, because there are the grounds raised in the notice, there are those 4 grounds of abuse by the South African authorities. They have not been adjudicated and should be adjudicated by that court and not this one.
Mr. Drengov, I know that you submitted as one of the preliminary points that you made before you dealt with the 3 main submissions, 1, 2, and 3. You made a reference to a statement by Ms. Cholota which never placed in issue, you say, the fact that it was the DPP and not the minister that could make the extradition request. Can you give that to me again, please? I just missed the reference.
We addressed it in our heads.
Oh, yes.
Let me just say the further point we made, the original point we made is in paragraph 18 of our heads, where we refer to the record, where Ms. Cholota's counsel raised this Schultz point for the first time in her replying submissions. The further point I made this morning was that Ms. Cholota says in her heads of argument, paragraphs 9 and 19, that this point, i.e. that the request was made by the wrong official, was already front and center of the application that she had made to this court for direct access. So I suppose she tries to say that the state couldn't have been surprised by this point because it had previously been made in her direct access application. And she says that in paragraphs 9 and 19, but that is not correct. That application, that direct access application is at page 166 of the record, and you'll see there that she said her case there was that the request in her case had been made by the Minister of Justice or the DG of Justice or the Department of Justice. She certainly didn't take the point that it should have been, that it was wrongly made by the NPA. And that is so, that was made clear in that direct access application in the following paragraphs, paragraph 5, 63, 42, and 57.2.
Yeah, I asked this because the contention is that that was raised in the direct access application, but also they say they raised it front and center in the first bail proceedings in the magistrate's court, and also that was in August of last year, and also in the High Court in September of 2024 when they came before for AJ. But that's the point they make.
I understand that. I wasn't there. I can't speak to those other proceedings, but there were other proceedings before other judicial officers. When she filed her special plea in this case, the rule required her to specify the grounds of her special plea, and she complied with the rule. She specified the 4 grounds. You can't then say, but you should have realized that I had a 5th ground, which I didn't mention.
Nothing else.
Mr. Trengro, if we look at the treaty, the extradition treaty between the USA and the government of the Republic of South Africa.
Sorry, Justice Tron, when you speak behind the paper,
Yes, so if we look at the treaty, the extradition treaty
yes.
between the USA and South Africa, Article 9, and what I want to cover now relates to the submissions you made about there being a valid court order extraditing Mr. Lotto back to South Africa, and that should stand. Article 9 sets out the request, what should be contained in the request in order for the request to be approved in the US. So the request can be approved in the US even though there may have been unconstitutionality in the first part that may have occurred in South Africa. That would not be before the US court. That would not be a consideration before the US court. The US court would consider whether the requirements of Article 9 has been met. So why then should a South African court merely accept that at face value and not consider if our constitutional requirements in respect of extradition have been met?
Well, because that inquiry to whether the request complies with US law depends on US law. We just don't know what US law
But isn't
requires.
that the point? That extradition inquiry in front of that case, in US court, is concerned with US law. It's a further step in the process.
Yes.
If an earlier step, which the US court is not concerned with, was irregular or unconstitutional, why should an order of the US court that considered subsequent steps in that process then prevent a South African court from considering the validity of the extradition?
Because the question before the court is whether the extradition was lawful. The extradition was made by US officials under.
Interrupt you, but that extradition started with the request from South Africa.
No, the extradition started with a court order. And the court order authorized the extradition under US law. The US officials acted under the court order under US law. If all of that complied with US law, it cannot matter whether the request complied with South African law or not. If it does matter.
If there was no request from South Africa, would we get to the US law state?
No, then there wouldn't be any process at all.
Yes, so the process starts with the request from
Yes.
South Africa.
Yes.
Now, if that request is flawed, can it be a defense or an argument to say we should not look at that part of the process because we have a US judgment that is concerned with another part of the process?
Yes, because we do not second guess US law. The
That was not a question for the US court to consider, and that's why I referred you to Article 9 of the treaty.
Yes, I have Article 9 in
Yes.
front of me.
Yes.
It sets certain.
Article 9 does not deal with how the initial request in the requesting country, this time being South Africa,
Yes.
what requirements must be met for it to be a valid and a lawful request.
Yes. Now, I understand what you're saying, but what matters, when we ask, was the extradition lawful or not? The answer is this was lawful under a US court order exercised by implemented by US officials.
The US court order relates to part of the process.
Justice
Yes.
John, may I just finish
Yes, I'm
my
sorry.
answer? I understand you say that there is a flaw underlying that court order, because here in South Africa, the request was made by somebody who was not authorized to do so. Whether it matters to the validity of that court order is a question of US law. I would imagine that they have some requirement of authority to make the request, but that is an issue of US law. We can't say that a US court order is rendered invalid because an initial process, which took part in South Africa, did not comply with South African law. The question is, did it comply with US law? There is no reason to think that it did not, and even if there is such a reason, it is not for our courts to second guess the US court.
Let's just consider this scenario. If the application or the request for extradition is made in South Africa and the respondent, let's call Mr. Lotto the respondent and the state is the applicant.
Sorry, is that the government or the accused?
The accused, the respondent.
Yeah.
And the respondent brings an application in South Africa at that stage to set aside the request for one or other reason that renders the request unlawful. It doesn't get to the US. And a US court would not consider, in order for, when that court determines the validity, that court does not consider the first part of the process. So a respondent here would be the subject of the extradition would have the benefit of testing our laws and the benefit of our laws and our constitution in particular if that request was not lawful. Why should that benefit be lost because at another stage of the proceedings the US court has made an order and not considered the initial process?
Well, for two reasons. The one is that the validity of the US court order depends on US law. It doesn't depend on South African law. And merely to say that the request didn't comply with South African law says nothing about the validity of the court order. But secondly, even if I'm wrong, a South African court just doesn't have the power to reassess a US court order on its merits. That is comity between nations, that our courts will not second guess the judgments of a foreign court unless it violates some very fundamental principles of ours.
Would our courts have the power to consider, let's just call it the first step of the process, even where there is an order from a US court? Would our courts be precluded from investigating or considering the lawfulness of the request where a subsequent foreign court has made a decision?
No, certainly not. I'm not suggesting...
Isn't that what we're anticipating?
No, not at all. The South African court is never precluded from assessing and determining the lawfulness of the conduct of a South African official. So a South African court may do so if it is relevant to an issue before it.
Despite the existence of an order of another court outside that?
No, with respect not. The South African court can determine the lawfulness of the conduct of a South African official. Where the question is whether a US court order is valid or not, then it cannot do so because that depends firstly on US law, and we don't know today what the US law on this issue was. But secondly, our courts do not have the power to second guess the American courts. So to say that we can investigate the conduct of a local official, yes, we can. But we cannot do so for the purpose of overturning or impugning a US order which was made by a US court under US law.
Let's look at Article 9 again, Mr. Trengro. 9.1 says, all requests for extradition shall be made in writing and it shall be submitted through the diplomatic channel. As you mentioned in your submissions, the treaty is silent on who must make the request. So that decision, that question was not considered by the US court.
No, we don't know. That depends on US law, not only on the treaty.
I'm referring to Article 9.1.
Yes, Justice Tron, but
Yes.
the US court operates not only under the treaty,
Yes.
it operates under the general requirements of US law, as the South African court would.
Yes.
And I would imagine that there is a rule in American law that if you respond to a foreign request, that you must make sure that the request is authorized. But we simply don't know whether there is such a US rule.
We don't know, and we don't have it before us. So why then, if we don't know all the information and we don't have all of it before us, should we then be precluded from looking at this aspect?
Well, for two reasons. Firstly, because we say that court, that judgment, that order must be judged under US law. And we don't know what US law is, and therefore we can't say it's wrong. But secondly, even if we knew what US law was, our court, as a matter of comity, does not second-guess foreign judgments, so that we won't interfere with that foreign judgment. We will say to the South African who complains about the foreign judgment, you go to the US and challenge the judgment in that jurisdiction, but I can't entertain a challenge to a US judgment in our courts.
The preamble of that same act. The last paragraph says, desiring to provide for more effective cooperation between the two states in the fight against crime. Doesn't that take it to the level of involvement of the executive?
Sorry, Justice Tron, I didn't hear the last sentence.
Yes, doesn't that imply the involvement of the executive of the respective countries?
At a broad level, yes, the treaty was negotiated by the executive, and our Constitution provides for the executive to negotiate treaties. And the treaty also provides for high-level communication at the ministerial level. So I'm not suggesting that the Minister of Justice is excluded altogether from the operation of the treaty. But that says nothing about the core question, and that is, who decides whether to prosecute someone who is in a foreign country?
Can you point to any other or any constitutional democracy which supports the contention advanced by the applicant that a prosecutorial authority alone makes the extradition request and the executive has got no role to play in that, apart from being a channel?
Yeah.
See what my concern is, and I'm speaking for myself here, is the oversight to be exercised in a decision by the NPA. Because the NPA has got a direct interest in the matter that it's dealing with. And should they alone decide, yes, we're going to do X, Y, and Z, or we're going to prosecute you, especially when it's extraterritorial, or particularly where it is extraterritorial, that there should not be some executive role to play in that decision?
Well, there is a very powerful and very unambiguous and clear principle established by Section 179 of the Constitution, that it is for the prosecuting authority to decide whether to prosecute someone or not. And we wouldn't countenance any suggestion in relation to a domestic prosecution that the Minister of Justice can veto a decision to prosecute. Why should it be any different if the accused is beyond our borders? Why then, a la Schultz, must that decision to prosecute become a political decision by a Minister of Justice? Seems to us to fly in the face of a very unambiguous constitutional and statutory protection of the independence of the NPA.
Would you agree that it's not a completely satisfactory state of affairs that this court has not been told what the role of the Department of Justice is and what the role of DIRCO is in a matter such as this? That evidence has not been placed before the court?
Well, that is at least in part so, because this point was only raised in replying argument. But let me say, it is a pure point of law, and it should not depend on the manner in which the officials, whether from the NPA or Justice or DIRCO, how they implement the law. It is an issue of pure law, and moreover an issue of pure constitutional law, which should be capable of determination without evidence on the manner in which officials understand it.
Now, if it's a question of pure law, why was the appeal in Schultz abandoned?
Well, because in the High Court operated under the precedent of Schultz, and therefore it had to determine the issue on the basis that the request had to be made by the Department of Justice. That issue as to the role of the Department of Justice and whether it processed and approved the request was not a focus of any investigation. There was some evidence about it, but not the focus. It was not the focus of an investigation.
This may be an unfair question to you because you're not involved in Schultz, as you've made very plain on a number of occasions. If it is a question of pure law, why was the appeal on the merit in Schultz abandoned?
No, that you must really ask Schultz, the Schultz prosecutors. I'm not only bashful.
Question of pure law that a court must and can decide.
Yeah, it is an issue to which I just don't have any knowledge, and even if I had, I'd probably be too shy to express them. but I really don't know.
Thank you, Mr. Trengrove. Chief Justice.
Mr. Trengrove, just one last question, because this bothers me. Are you able to fathom any suggestion why the Extradition Act is silent on outgoing extradition requests?
Because it's already catered for by the Constitution and the NPA Act. Not in so many words, obviously, but the structures and the laws are already in place for the NPA to make those requests, because they are outgoing requests, they are an incident of prosecution. What is not catered for are incoming requests, because that's got nothing to do with the South African prosecutorial services, and that's why the Act had to create structure and processes to deal with incoming requests.
Because the Extradition Act deals specifically with requests that come in, and the role of the department.
At length, indeed.
And going out, it's silent, and you're saying it's because there are domestic arrangements that are located in the Constitution as to how that should happen.
Yeah, and let me say it's not only pragmatic, it's also principled, because it wasn't necessary to create processes for the making of outgoing requests. As far as incoming requests are concerned, those requests are, as a matter of constitutional law, none of the business of the prosecuting authority. The NPA doesn't have jurisdiction over incoming requests because they do not concern the prosecution function in South Africa, which is the function of the NPA. So it's not only that pragmatically the institutions and the systems did not exist, it's because that function falls outside of the function of the NPA under the Constitution.
Thank you.
Mr. Trengov, I have a couple of questions that concerns me. Perhaps I should start with the debate that you had with my sister Teron and put the question this way. Does it matter or it doesn't matter what underpins the request for an extradition? In other words, if as the respondents contends that the bedrock of the request on their own version has been tainted with some lies, representations, which, according to them, vitiates the lawfulness of the extradition. The fact that that request was placed before an American court, and the American court, acting on what it presumed or thought it was a valid request, made an order to extradite the accused. So for the purposes of our discussion here, it doesn't matter on your formulation. Is that the argument that has been presented?
No, it might matter, but whether it does is a question of American law, and we don't know what that law is.
I don't understand you.
The extradition request was adjudicated upon by an American court.
We accept the American court adjudicated that request.
But you asked me whether it mattered that the request was unauthorized. I say that the answer to that question depends on American law. I don't know what American law says, what the requirements are for an incoming request for extradition.
But if we now have evidence that seeks to suggest or demonstrate that what was placed before the American court by certain officials appears to have been some distortion or misrepresentation, we can walk away from it? Or is there anything that we can do about it? Or because it's an order of the American court, that order must be set aside up there or down there, depending where the geography is?
No, with the greatest of respect, there is no suggestion that that any misrepresentations were made to the Americans. The order was made, the extradition was sought by the NPA, and I'm sure that that is what the Americans saw. So there was no misrepresentation. Whether the American law requires the request to come from one public body or another public body is a question of American law, and I simply can't tell you.
So the short answer is, whatever has to be challenged must be challenged in the American courts, not?
Yes. That's the very principle that underlies the comity consideration that I refer to. Our courts won't sit in judgment of a US court, because if the US judgment is flawed, then the remedy lies in a challenge in the US. But we won't sit in judgment on a US court order.
And if two police officers claims to have no knowledge of how the extradition processes operates and claims not to have any knowledge of how they successfully managed to obtain the extradition order. I'm talking about the judgment now, the High Court, because they seem not to be aware or have any knowledge as to how things unfolded up there. and this is the evidence upon which one operates, which happened during the trial, within the trial, would that evidence have any bearing at all or nothing?
The evidence that was actually led was led in response to the special plea, which said that the South African authorities lied and cheated in supporting the request for extradition. That 1,000 pages of evidence is utterly irrelevant to the question before us today, because those were officials who had no idea how the paperwork was handled and couldn't testify to it. But that lack of evidence on the issue that you now raise with me was due to the fact that this point was first raised in replying submissions after the state had closed their case. So yes, there is no evidence before the court, but that is precisely because this point was not raised at the outset and was only raised at the end.
So for the purpose, just want this for my own understanding, for the purpose of this case, the issue, correct me if I'm wrong, the issue seems to be narrow. Who has the authority to make this outgoing?
Yes.
And if the answer is in the affirmative, right? Whatever happens in America by the two officials, whether they distorted or did not distort, the fact would be the relevant authority in South Africa that made the request on your own submission would be the NPA, and that would be the answer.
Yes. Well, that much is at least clear, that the request was made by the NPA, so that there is no ambiguity about.
So the foot soldiers should not suffer any blame.
No, because
There were police officers who had gone to
there are two answers to that question. On the question whether the request was properly made, on the question as to who made the request, there's no ambiguity because the request is part of the record. We referred to it early on. So there's no ambiguity about it. On the question whether there was misconduct involved by the South African police services in making misrepresentations to the US, that is not a question that's before you, and that is the question that we would submit should go back to the High Court for it to determine on the evidence before it. But that doesn't help. That has no relevance to our inquiry today.
The other issue is the one that you've just adverted to now. It's the High Court. The High Court did not, which my brother Colapan dealt with. The High Court did not deal with all the other issues, but one.
Yeah.
It says in paragraph 17, it's not necessary.
There's the killer point.
If in the event we are against you, please listen carefully to my formulation. If in the event we are against you on the first point, on the authority, are you able to come home on the second point, that is the authority, the US court, to say, even if I'm wrong on the authority to request the extradition, because the judgment of the US court has not been set aside, it remains a valid judgment for all intents and purposes. So would you be able to come home on that point?
Yes, we submit with respect clear law to that effect, so that this court would then hold.
And how would you be able to come home on that point when there is no judgment on that point at the High Court?
No, you would say that
the High Court did not deal with it.
Well,
we would then be arrogating to ourselves the powers as a court of first and last instance. It was not dealt with. Can we then deal with it?
Well, it is a pure point of law on the implications of the issue that was before the High Court. The implication is, the question before the High Court was this request lawfully made? Now, you asked me to postulate that the High Court was correct in finding that the request was not lawfully made, well then it's a question of law what the implications are of that conclusion. Does it justify the conclusion of the court that Ms. Chilota should be told that she's free to go, or does it not justify that conclusion? We submit that it does not, for two reasons. Firstly, because the High Court, the US order stands unblemished by this finding. Thirdly, the Abraham principle is not triggered. So there are two further grounds upon which this court would set aside the High Court judgment, even if you were to find that the request was not made by the correct party.
So for us to deal with the second point, you would say, absent the judgment of the High Court, this is a point of law, we can make that determination.
Yes, and it flows from the finding of the High Court. The High Court jumped from its finding that the request was unlawful to a conclusion that therefore Ms. Chilota may walk. We submit with respect that that jump incorrectly failed to recognize that there were two further questions to ask. The first is, does the wrong request impugn the US judgment? And even if it does the Abraham principle kick in?
But now, if you look at the Ibrahim principle, does the conduct of the two police officers comes anywhere closer to the Ibrahim principle? Like what the British authorities characterize as an affront to one's public conscience.
Yes.
And
No.
if it is correct that people went to America and lied,
Yeah.
and based on their lies, the American authorities acted upon their misrepresentations, and doesn't that offend one's public conscience?
It might do if those were the grounds upon which the High Court made its order. But the High Court didn't do that.
But there lies the problem.
No, with respect not. The High Court didn't find that the request was unlawful, and moreover, the request was tainted by grievous misconduct, and therefore Ms. Chilota can walk. The High Court jumped from the finding that the request was unlawfully made to the conclusion that Ms. Chilota can walk. We submit with respect that that jumped over our points 2 and 3, and it is not, the court erred in ignoring our points 2 and 3.
But
So what this court will do, we submit with respect, is to find that if it finds that the request was unlawful, then it will find, but the US judgment stands unaffected, or alternatively, the mere fact that the request was unlawfully made does not trigger the Abraham principle, and send back the matter to the High Court to determine the rest of the special plea still stands. 4 grounds of it.
let's go to the section itself, 179. B. I think it's 179(2). Let me read it out aloud. It says the prosecution authority has the power to institute criminal proceedings on behalf of the state. There is no quarrel with that. There is no quarrel with that.
Sorry?
The first sentence that I've read, there's no quarrel with that.
Yeah.
And to carry out any necessary functions incidental to instituting criminal proceedings.
Yes.
Is this capable of an interpretation that to carry out necessary functions would inter alia include that, 1, the NPA must put up necessary documentations, i.e., documentation for the purpose of extraditing a person, and lay those documents before the minister. Would that be a correct interpretation or is it
With
straight?
respect, not. Because it gives the Minister of Justice a veto power over any prosecution. Take that example and apply it to a local prosecution. What would we say if this were interpreted to mean that whenever the NPA wants to prosecute somebody, they must first make a case to the Department of Justice? That would be a flagrant violation of this constitutional guarantee. Why should it be any different if the accused is not in Johannesburg but in London? And with respect, one shouldn't read this clause as if it stands unelaborated upon by this court. This court, in its certification judgment, made it clear that this is a guarantee of prosecutorial independence. It is incompatible with an interpretation which gives the Minister of Justice a veto on the decision to prosecute.
Okay. Finally, if we are with you on the first point, then
it's a nice premise.
then it would mean, by implication, we would have crossed a black line on the Schultz matter.
Yes.
Notwithstanding the fact that it is not before us. We just hit it. We just hit the Schultz matter.
No, with respect, you would treat, in our case, in Chilota,
Yeah.
you will treat Schultz as you do any other precedent of the SCA.
Oh.
It is worthy of respect, but it's just a precedent. And it's not binding on this court, and the court has free license to consider afresh whether it was right or wrong.
Then if again we are with you,
Sorry, Justice Topo, may I perhaps just elaborate
Yes.
on that? The Schultz judgment has res judicata implications in the Schultz case. And I'm not saying anything about those res judicata implications in that case. But what I am saying is that if I am not a Schultz, subject to the Schultz res judicata of the SCA judgment, then the SCA judgment is a mere precedent. And
but it's a mere precedent that will not be followed.
yeah,
If you obtain victory before us.
yeah. And I mean, you would treat it as any other precedent. SCA's judgments are worthy of respect, but you're not bound by them, and you'll consider afresh whether they're right or wrong.
Then when I read, I must just confess, when I read, I was just a bit worried about the ambivalent positions that has been adopted by the NPA. But if you are successful on your point, then my concerns about these ambivalent positions would not hold, because they would say, yes, we had been vindicated.
No, well, there's obviously an ambivalence, but an ambivalence between two cases. In the Chilota case, there is no ambivalence about the position taken by the prosecution on the core question.
Okay, thank you, Mr. Stangov.
Mr. Trengrove, just to carry on from my brother's question, and actually he's covered most of it, but I just have a slight conceptual difficulty that with Schultz not having been appealed on the merits, is it even competent for this court to hear what is in effect a Schultz appeal, but in a different matter?
No, you postulate that there's an SCA judgment in Schultz, which on the merits is a final judgment. As you would in any other case where an issue has already been determined by the SCA, that precedent stands, but the same question then comes up in a different case. And you would say in that second case that we're not bound by Schultz. It's a precedent of the SCA. We'll consider it with respect, but we are at large to determine whether it was right or wrong.
Even though we are hearing the Schultz case now, and they haven't appealed the merits.
Yes, I'm asking you, you can postulate that Schultz is dead in the water. That, in other words, that the SCA judgment in Schultz on the merits has become final. But Chilota is a different case. It is not bound by, under res judicata, it is not bound by anything said in Schultz. It is bound by the precedent set by Schultz, but this court is not bound by that precedent. This court is at large to decide whether Schultz was right or wrong.
So if we find for you, then we really, or if we're with you, then we really shouldn't bother about the argument on prospectivity or retrospectivity.
Well, if you find for me, that would solve the NPA's problem in all cases except Schultz. And how you decide Schultz would then matter only to the Schultz extradition and not to anybody else.
Thank you, Mr. Trengove.
Thank you,
We
Deputy
are going to take the tea adjournment. It's going to be 20 minutes. Court adjourned.
Sorry, I said sorry.
a good day once more. Let us be ready. Thank you.
Please rise for the Constitutional Court.
Ms. Macapella?
Thank you, Deputy Chief Justice. Members of the court, I intend to structure the sequence of my submissions as follows. First, I will deal with the contentions in relation to the American courts. Secondly, the contention by the applicants in this matter that it is the NPA that is vested with the authority to make requests with particular reference to Kaunda. The third is that the contention by the applicants that the Schultz issue was only raised at closing arguments. Fourth is that the applicant states that the errors that are prevalent in the extradition request were errors, and I quote, in good faith. And also, finally, the fifth and sixth point will be that none of the points that the applicant makes before this court were advanced by the NPA or the prosecution in the court of quo. And finally, the issue on the affront to the public conscience. The first is the submission that has been made by my learned senior counsel, Mr. Trengove, that there isn't any indication as to what it is the US courts considered or were privy to. This is incorrect, and I wish to point the court to two instances in the volume. The first is the certification by the magistrate in the US District Court of Maryland that can be found at volume 19. The second is a memorandum by the prosecutor, or our equivalent of a prosecutor, in the US court, in which he explains what it is that Ms. Cholota is to do with the merits of her case. And that appears at volume 2. We start first with what is contained in volume 19. That is at page 1914. At the very top, in the United States District Court for the District of Maryland, certification and committal for extradition. Deputy Chief Justice, members of this court, from numbers 1 to 9, the magistrate in that court sets out what it is that the United States court needs to look at and ascertain before extradition can be certified, or before a fugitive can be certified extraditable. And if on the following page regard is to be had to point number 9, the magistrate there states that her finding rests upon the documents submitted by the government of South Africa in this matter, including inter alia affidavits from the South African prosecutor and lead investigator, the indictment, and a financial forensics report. The rest of the points are purely procedural. This investigation by a court as to the extraditability of a particular individual is purely procedural. The merits of the matter are merits that are better suited for the home court. And I do not say that on my own accord. When one has regard to volume 2, that is at page 128, but it starts first with a motion to proceed with extradition hearing. And if I may provide just a brief background on this, Ms. Cholota was arrested in the United States and she was held in detention pending the extradition hearing. When she found out the details or the contents of the extradition request and had issues therewith, she then launched proceedings, urgent proceedings on a direct access point before this court. In order to do so, she sought a stay of the proceedings in the United States court, and this document is the application that the United States makes in order to say that the proceedings ought to continue. And the specific reference is at page 128, right at line 8. It says there, and line 7, my apologies. As to the second factor, while Cholota may argue that her returning to South Africa constitutes irreparable harm, there is no basis to believe that she cannot prosecute these claims while in her home country. And so it is quite clear, Justices, that no merits of the matter were before the United States court, nor could she bring such merits before the United States court. And so the point on comity that has been advanced cannot stand. Because for it to stand, the merits of the matter ought to have been traversed or presented before the US courts. This was purely procedural. And on the point of purely procedural, it is because the United States only considers these extraditions, and so does South Africa in turn, on the basis of whether or not they are going to be in line with the requirements in the treaty, their treaty obligations. And if one has regard to the arguments that this particular prosecutor advances, they state that we at the end of the day have got treaty obligations to the government of South Africa. And so that is the basis for the extradition hearing, and it is purely procedural. The second on this, Justices, is that in each of the cases that are advanced on extradition, at each point, there is no indication ever of an extradited fugitive launching an appeal in the state from which they have been extradited. At all times, these challenges take place in the country that the person has been extradited in. And that was the case in the Ibrahim matter that was advanced. That challenge, although he was extradited from Eswatini, that challenge was launched in South African courts. And the cases are replete with these cases. But be that as it may, the main point is that the argument on comity cannot stand because the merits of Ms. Cholota's extradition were never advanced before the US court. It was a purely procedural exercise, and in those 9 points, that magistrate goes through what it is she had to ascertain. She had to ascertain whether the person being sought was in her jurisdiction. She had to ascertain whether there was an extradition treaty that existed between the two countries. She had to ascertain whether the offenses that are sought to be tried in that country are offenses in the US, and those are the procedural element. And of course, one can answer yes to all of those. But the basis for Ms. Cholota's challenge under Section 1061F before the Court of Quo was on the basis of that 9th point, that the magistrate stated that the basis for her considering her extraditable over and above these procedural elements was a consideration of the prosecutor's affidavit, the forensic report, and the investigator's report, all of which the evidence on itself and the facts that were evident from the witness testimonies indicated gross irregularities, indicated false misrepresentations, and indicated blatantly misrepresented facts that were communicated as truth. Now, the United States court could not ascertain whether or not those facts were true. They relied on the truth of the truth of the if I may just take a moment to collect my thoughts, the truth of the representation made by South Africa that the documents that they had submitted are true and correct. It is for this point, Justices, that it cannot be the prosecuting authority that has the authority to make these requests, because they have a vested interest in the particular prosecution and will make exaggerated claims such as the prosecutors in this case made. But a minister, being a member of the executive, has the treaty obligations, and it is the minister that is signatory to the treaty. And that is because the treaty obligations are over and above the criminal matter. That is why it has to be a member of the executive that adopts this particular function. Now, this takes me to the point of the submission that was made by the applicants that that this court ruled in Kaunda that it is the NPA that has the authority. Justices, with respect, if I may, direct this court to that particular paragraph in Kaunda, paragraph 83. That is not a correct interpretation of what is contained in that case. At paragraph 83 of the judgment, it states there that in terms of the Constitution, the prosecuting authority, headed by the National Director of Public Prosecution, has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to the instituting of criminal proceedings. This would include applying for extradition where this is necessary. The powers of the prosecuting authority, and this is where it is important, Justices, for which the Minister of Justice and Constitutional Affairs assumes the final responsibility, must be exercised by the prosecuting authority without fear, favor, or prejudice. Decisions to institute prosecutions may raise policy issues which are far from easy to determine, as in the present case, the events are already the subject matter of criminal proceedings in another country. And so the interpretation with respect is not a complete one. It is incorrect. That is not what this court held in Kaunda. This court did not hold that the NPA has the authority to make extraditions from another state. It held that the NPA, in terms of its functions, may institute requests for proceedings. And with this, I wish to point out, in substantiation of my point, we made the point in our heads of argument that the Director for Public Prosecutions in this matter held that it was the minister as the member of the executive that had the authority to request extraditions on 25 September, in our case in the High Court in the Free State. And yet in this court advances a different and contradictory position, namely that it is now the NPA that has that power. Justices, we ask for this court to put this to the applicants and for this DPP to indicate which position it is that she wishes to advance under oath. Is it that it is the Minister of Justice that has the executive authority, or is it what is advanced before this court, and for the first time on heads of argument, that it is the NPA that has the authority? And this then brings us, Justices, to the following point. In light of, notwithstanding the fact that that point was made for the first time in the heads of argument, what is the minister to do? Is the minister to observe the Constitution and her constitutional obligations under Section 165 to obey court orders? Or is the minister to disregard a court order that is valid and binding and instead observe what is stated by the NPA? Where is the source of law for that, practically? If the minister is to disregard extraditions and say she's not going to make the extradition request and represent South Africa as a member of the executive, is that not her completely disregarding her executive authority and a court order? That is one of the practical considerations that must be traversed with the applicants. I now move on to the third point, that the point on the Schultz matter in the quota quo was only raised at the closing argument. We've dealt with this, Justices, at length in our answering affidavit to show that this is not the case. We deal with it in our heads of argument, but I would like just to traverse the sequence once more. At paragraphs 18 and 19 of the applicant's application to this court, they tell this court that the Schultz judgment was handed up at the commencement of the cross-examination of Captain Kalitz. Cross-examination. When they were asked if they had any objection to the judgment being handed up, their response was that they had no objection. That was the first opportunity. That was the first opportunity that they could have taken to advance the representations they advanced before this court on Schultz. Secondly, the re-examination of Captain Kalitz was done by the prosecution. When this exhibit was handed up, it became part of the record. If, in fact, the prosecution wished to take this opportunity to make these representations, they could have put it to the witness at re-examination. That was the second opportunity. The third is during their own close of arguments. They could have put this and argued the points that they argue in this court before that court. There was nothing that was stopping them. This judgment and these points were already part of the record. It is only when the defense for Ms. Cholota advanced the argument that the reason why they were unable to prove their case was because they did not call a single relevant person to speak to the legality or the lawfulness of the extradition. That is when the lights came on that this was something that was fatal to their case. And that is the position that the judge in that matter took in the court of quo. He cannot be faulted for applying a position that was raised properly before the proceedings. Nor can he be said to have denied the prosecution of an opportunity to make representation when all these four representations could have been made. And so that point, that it is something that needs to go back to the court of quo so that the prosecution can have an opportunity to make representations of Schultz, cannot stand. The fifth, Justices, is the fact that there was a point made that Ms. Cholota did not, in the direct access application that she brought before this court last year in June, make the argument that the NPA's request for extradition was unlawful. This too is incorrect. If I may please reference volume 2, page 166, paragraph 6.2, that's line 17, 6.2. She says that she seeks the following order, an order that the extradition request made by the Office of the National Director for Public Prosecutions and the National Prosecuting Authority is unlawful and wrong in law. It was part of her case that request was unlawful and wrong in law, and the main basis for that was that it was not made by the Minister of Justice, or it was not properly considered by the Minister of Justice. If I may then just drag this point a little bit further, the case is that had the Minister of Justice had sight of this extradition request, she or someone in her office would have seen that some of the contents of this extradition request actually offended the extradition treaty. But for the point for the reasons of this particular point, that point was made, and it was made again at page 173 at paragraph 22. And she states there that this case concerns the gross abuse of power and violation of constitutional rights by organs of state that are required to uphold the Constitution and respect the rule of law. The conduct by the NPA and by extension, the Department of Justice, is inconsistent with the Constitution and warrants this court's intervention. And so, indeed, it has always been her case that this extradition was supposed to have been advanced to U.S. authorities by the minister and with the minister's approval, particularly when the decision of the SCA was handed down. And to Justice Colopin's point about the retrospectivity, we submit that that is not applicable in this instance, because when the Schultz judgment was handed down, Ms. Cholota's extradition hearing had not commenced. It commenced on the 7th of June 2024. And so there was nothing stopping, and this is our case in the affidavit, there was nothing stopping the NPA from informing US authorities that there was a judgment now that specifically specified it was the minister that had to make the request, and then submitting documentation in support thereof, or ratifying. And in our answering affidavit, we do make the point that we say this because it was the minister herself in a televised interview that stated that she had caused all the pending extraditions to be brought to her office, and I quote, so that I can ratify them and approve them. And so the minister herself informed the nation that this was something that she was actively doing. But nowhere in the papers does the applicant bring this court to their confidence in order to explain why it is that this was not done when the Schultz judgment was handed down. And justices, there was a point that was made that this court is not bound by Schultz. Even if we accept that, that is not the question that is actually before this court. The court that was bound and is bound by Schultz is the court quo. Lobsha J is who is bound by Schultz and remains bound by Schultz until Schultz is set aside, which it has not, because no appeal for Schultz is before any court. And so while this court cannot be bound by Schultz, the main point remains that it cannot be found that he was wrong in law or came to a decision that a reasonable judge in his position would not have come to when one considers the fact that he applied a valid and binding decision, which decision remains valid and binding. And finally, justices, if I still have time, the final point is in relation to what the applicant states in their heads of argument with reference to the Latif judgment, stating that the facts in this court, that are before this court do not trigger the Latif application, that they are not an affront to the public conscience and do not require that this court interfere with the prosecution. That is, with respect, not true, justices. And I wish to quickly just traverse the very particular sequence, the sequence that is relevant on this point, that this indeed affronts the public conscience. Justices, on 11 January 2022, that is when the extradition for Ms. Charlotta was sent to the United States. This was done without her ever have been certified a fugitive from justice. She was never a fugitive from justice. She was in the United States studying for a Bachelor of Science in Political Studies. So that's the first one, the request for extradition of someone that is not a fugitive from justice. But when that did not succeed, and we see this with the request for further information that the United States Department of Justice sent to the prosecutors on 18 January 2023, and that is at volume 1, page 88. And that letter takes us through the multiple instances that the United States asked the prosecutors for further information. They wanted an explanation as to the elements of the offenses that Ms. Charlotta was charged with. They wanted her connection to the fraud scheme. They wanted her connection to the money laundering charges. And they stated that we're going to send you this link to help you understand that probable cause is required in the United States court. And they stated that on the basis of the information that they have, they do not have a factual basis necessary to support the charges. And so it can be taken that on the basis of the extradition request that was submitted to US authorities in January 2022, no case was made out for a valid extradition. But after that, the prosecuting authority, and this is evidence that the witnesses conceded to, went and pressured and influenced the Director General in the Free State Department of Free State Provincial Department, who had given Ms. Charlotta her bursary, and influenced him to terminate that bursary, which in turn led to the withdrawal of her sponsor. The reason why this is important is then the prosecutors, and this is all in the evidence, the prosecutors then informed the Department of Justice, which informed the ICE Immigration Agency, which arrested Ms. Charlotta and tried to deport her. The only reason she was not deported was because she had a full scholarship from the Bay Atlantic University. This is at volume 17, pages 170.5, where in the email correspondence from the Department of Justice indicates that it was the prosecutors that informed them of this. When the deportation did not succeed, the next thing that they tried to do was that a red notice was issued on Ms. Charlotte, an Interpol red notice, again to bypass extradition and try and ascertain a deportation. That too did not succeed. And this is when, Justices, we have a forensic report that comes up on the 6th of June, 2023, that was not part of the original packet. And this forensic report is what the magistrate in the US court says she based her decision on. It was accompanied also by a further amended affidavit of the prosecutor, which we went through in the court of quo and showed that it was based on misrepresentation. And so in this instant, Justices, the NPA and its prosecutors and investigating authorities tried every single thing unlawfully to get Ms. Charlotte to this country without need therefore ever having been. And we submit that if we were to say that this court has jurisdiction, it would indeed be an affront to the public conscience, because it would say that those actions by the prosecuting authority are constitutional and lawful, and that is something that this court simply cannot say on the basis of the rule of law and on the basis of the rights that underpin the Bill of Rights. And so, Justices, even on their own argument, the applicant must fail. It advances a case that it did not bring before the court of quo, nor a case that was brought before this court in the papers. It advances a case that was brought for the first time in the heads of argument. That cannot be. And that case is required to appeal a case that is not before this court. That too cannot be required. That too cannot be allowed. So on that particular point, they fail. Secondly, they did have audi alteram partem in Schultz, but they chose not to make those submissions. The state was required to prove its case beyond reasonable doubt and failed to do so. That is a hurdle that the applicant cannot, by any measure or interpretation of their case, cannot surmount. They did not make out a case. It was not because they were not granted audience on Schultz. It's because they did not make out a case that the court ruled against them. And then finally, even if we are incorrect on all of the above, the facts of this case clearly prove that the manner in which the NPA and the officials in the investigating, the police investigating officers, the manner in which they went about this extradition was completely and utterly unconstitutional, and it cannot be rectified by a finding by this court that the court of quo has jurisdiction, or the criminal court of South Africa has jurisdiction over Ms. Charlotte. And so the application must fail. But if it does not, and this court grants leave, we submit that the appeal has absolutely no prospects of success.
Thank you, Ms. Makapela. Wasn't Ms. Cholota a candidate for deportation in any event for overstaying her visa? Because that's what one sees in the letter that the U.S. authorities wrote.
That is not correct, Justice. When a sponsor withdraws their visa, that means that the person ceases to have a valid reason for being in the United States and is considered to have overstayed their visa. That was the basis upon which ICE detained her, that she no longer has a sponsor, and so as a result, she cannot be lawfully in the country. And the only thing that remedied this was her proving that she had a full scholarship from the Bay Atlantic University. And in the communication from the U.S. Department of Justice to South African authorities, the lady there makes that clear, Maria Lerner from the U.S. Department of Justice. She makes it clear that the only reason she was not successfully deported is because she showed the evidence of the scholarship, and she was released on condition that she remains in school and continues with her studies. And so that's why she was never arrested again after that. But the main importance in this is that in all of the court documents and sworn statements that the state and the prosecutors and investigating officers deposed to on this point, they denied it. In the magistrate's court, they denied that they had any involvement in this. In this court, in the affidavit, they denied that they had any involvement in this. In the high court, they denied. It was only when the documentation from the email correspondence was revealed in the court of in the trial within a trial, that it was ascertained without a doubt that indeed it was the state prosecutors, because the letter starts with "at your request," which means that it was the prosecutor that made the request to the U.S. Department of Justice that they alert ICE authorities, and she confirms that we have done this, but it has not yielded a deportation because she is the holder of a full scholarship. And so we submit that that is not correct, Deputy Chief Justice.
Thank you for that. Your case here, in response to the case brought by the applicant, is that it is actually the minister that has the power to request extraditions. That's your case.
Yes, Deputy Chief Justice, that it is the minister that has the power to request an extradition from another state.
Yes.
That point, I think, it keeps getting lost in the...
So let me just understand this, because I think I asked Mr. Trengo the same questions. So the NPA can take the decision to prosecute, and then if it wants to prosecute someone who's not in this country, you say it can't take that decision. It has no power to take that decision.
That is not what we say, Deputy Chief Justice. The NPA makes application to the minister, and it is the minister, upon having approved that request, that makes the request to the state. In response to this, could I please inquire if a document that we sent yesterday to the registrar of this court was circulated to the justices? A 28 September 2023 article by the Minister of Justice on extraditions.
Yes, my colleagues confirm they received it. I don't recall seeing it.
My apologies, Deputy Chief Justice. If I may please make a reference to an explanation given by the then Minister Ronald Lamola on the process in relation to the Gupta's extradition.
Yes.
So he sets out a number of extradition requests that are coming from other countries to his department, and then the extradition of Mr. Bushiri is one that the South African authorities are requesting from Malawi, and then on the following page, it is the extradition of Mr. Atul and Rajesh Gupta from the UAE. This is before Schultz was decided, Deputy Chief Justice, and therein the Minister of Justice indicates that himself and the Director General went to the UAE to discuss the extradition of the Gupta brothers, and that they met with His Excellency the Sultan. And then when they came back to South Africa, it was the prosecutors, the South African prosecutors, that liaised with the UAE officials. And then when official correspondence had to be sent, it was the minister that appears at the fourth paragraph at the bottom, as well as on the following page at the very top. It was the minister and the Director General that wrote to the UAE to ask, have you received our letter? We cannot file an updated extradition request without the responses to this letter. And so that is what we say. Even in the other extradition, particularly the one of Shepherd Bushiri, the minister indicates that an extradition request was received by the department from the National Director of Public Prosecution. And so the interpretation there is that the NPA must make these extradition requests to the minister, and it is the minister in their executive authority that must make these requests to the requested state, because they are the ones that were signatory to the extradition treaty, and they are the ones with international law obligations to ensure that those treaty obligations are met. It is not the prosecutor or any prosecuting authority. And as a final point in just response, Justice, when one has regard to all the correspondence that the prosecutors had with the United States, one will note that it was with the U.S. Department of Justice, not the corresponding prosecutorial authority in the United States. And so that indicates that that is an international law obligation that cannot be assumed by a non-executive state authority, which is what Schultz says, what the SCA and Schultz says.
Well, let me ask you another question that I asked Mr. Trengove. Why do you think the Extradition Act is silent on who has the power to request extraditions from other countries?
I'll answer this, Deputy Chief Justice, with reference to a case. I unfortunately do not have it in my head, nor do I have the proper reference, but it's a case by this court that was penned by Justice Albie Sachs-Quigliani. And that question as to whether or not, which official was it that was supposed to make the request and why the act was silent, there's an indication in that judgment that because the minister is referenced all throughout the Extradition Act, it can be assumed, and the NPA is referenced nowhere in the Act, it can be assumed that the intention of the legislature was that it is the minister that had the powers in relation to what the Extradition Act states. And so I'll have to align myself with that line of thinking that at the time in 1962, when the Act was enacted, perhaps legislators did not think that a state clothed itself with executive authority and assumed that it was the one that needed to make requests from other states. But beyond that, Deputy Chief Justice, other than to quote Quigliani and assume that that is what that justice meant, I do not have a definitive answer to the question.
Thank you very much.
Ms. Makapela, on this issue of the decision to prosecute, you accept that the NPA has that power to make
That is
a
correct,
decision.
Justice Mdlandla.
And it can also make a decision to request the extradition of a person from another country.
Indeed, to the minister. We do not accept that they've got that power to request directly from another state.
So they will prepare all the documentation and submit the documents to, for the extradition of that person to the minister.
Indeed, indeed.
What is the role of the minister? Can the minister change that decision, make any amendments, or if the request of the, or decide to say that you don't have the right or there is no reason for you to seek this extradition of this person?
Thank you, Justice Mdlandla. Our position is that because the treaty obligations are signed between the minister and the other state, the reason why this is the minister that needs to ensure that that particular extradition document is in line with international law obligations, which is something which prosecutors cannot do. An example on this is the reason why we brought, or why Ms. Charlotta brought the application last year to begin with, was her claim that the extradition request offended the section in the extradition treaty against seeking extraditions for political purposes. And so it would be the minister that would have that authority or that executive function to investigate and look at whether that particular extradition request offended the particular provisions of a treaty. We submit that that is the reason why, or rather the role of the minister in those instances. It is not to, as I think my learned senior counsel put it, to veto as is the case that we advanced before this court as to why it is the NPA never brought our request before the minister, is that in instances where there is evidence of prosecutorial misconduct and false fabrications made by ministers, made by prosecutors, the minister would be able to look at that and see that it does indeed offend the relevant provisions of the extradition treaty, and it would guard against what the Justice Mabindla Botwana referred to in the Schultz judgment as an undesirable consequence. And so to have the NPA be the organ of state that makes these requests from states does not guard against that, as is evidenced by the facts and the evidence in this case.
Right? Would that not be against the provisions of the Constitution for the minister to decide whether or not this particular application should be submitted to the relevant state, because now it has this the minister has this veto power.
Well, if it offends Justice Mdladla, if it offends international law, then that request would, in actual fact, be unconstitutional. And so the minister is well within her rights to guard against an unconstitutional act by a state organ under the guise of a prosecution being sought. And so it's not something that the minister can just do whenever. In our submission is that this is not a function that the minister can simply exercise whenever. It is in relation to the treaty obligations and whether or not that particular document offends the treaty obligations, which is what the U.S. counterparts in their judgment kept on insisting that they did not want to do. They did not want to offend or contravene their treaty obligations. So that would be the role of the minister, but with everything, with the Constitution underpinning her conduct and her actions in that regard.
It says it's only the minister that has the power to make the request for extradition of the applicant from the United States. That will be the last leg, basically, of the process.
That is correct.
It doesn't say anything about the role played by the NPA, which will be before this particular stage. What should we make of that? Because surely the minister doesn't make the decision, prosecute, or the decision that this particular person must be brought back to the country. That is the NPA's role.
Yes.
Where would we find that in this declaration?
Well, that would be why we handed up the document from the Minister of Justice dated 28 September 2023, Justice Mdladla, to indicate that that is the process that is ordinarily followed, that the NPA sends its request to the department. And in fact, that is what this applicant before this court stated in the High Court on the 25th of September. If I may please take this court to our heads of argument at paragraph 29. The Director for Public Prosecutions there states that the Minister of Justice and Constitutional Development has not been joined to these proceedings. She is a member of the executive responsible for facilitating extraditions under the Extradition Act 67 of 1962. And to the extent that the applicant seeks declaratory relief pertaining to the lawfulness of her extradition, the minister ought to have been given an opportunity to respond. The extradition process, while motivated for by the Office of the Director of Public Prosecution in whose jurisdiction the charges are to be pursued, is handled by the Department of Justice and Constitutional Development and the corresponding authorities of the requested state. And so this notion now that this is a new concept or this is a foreign concept that was never before any court, that is debunked by the DPP, this applicant's own version under oath, in which they explain the process, that with the counterparts in the requested state, the Minister of Justice facilitates the extradition request upon presentations being made to it or motivated by the Office of the Director for Public Prosecution. And they cannot now do away with that position when it appears that that was the case before Schultz was decided, which was then confirmed by Schultz, and then further confirmed by themselves under sworn oath in this affidavit.
I can't recall. You said the operative date for the extradition hearing, the date that should apply to Ms. Cholota's matter, is the date when the hearing was commenced, which is the 7th of June 2024, and not the application for extradition was made by the South African authorities.
That is correct, Justice Mdladla. In particular, when one has reference to the communication that I referred to in my opening submissions, that the United States Department of Justice sent to South Africa, that the extradition request of the 11th of January 2022, as it was insufficient to secure an extradition. So when one has regard to that, it would have failed if the United States, as it was at the time. a further extradition, or rather, further documents were submitted, and these were documents that were submitted after the fact. And when the extradition hearing commenced on 7 June 2024, there was nothing precluding the prosecutors from involving the minister, from having the minister ratify the extradition request, from having the minister file a further affidavit. And I say this because that is the advice that the US authorities give to South African prosecutors when explaining to them how they can submit an amended affidavit. They say that you can just depose to the affidavit, and then this will be incorporated into the extradition packet that will go before the court, the U.S. District Court in Maryland. And so there's nothing, during the court of quo, there were no submissions made as to why that did not happen, nor in this court on the papers. The applicant is silent as to why a judgment was handed down on 24th of May, but at a hearing on 7 June, the court and the magistrate judge in that court, the fact that there was a further document that was required under law in South Africa.
Thank you, Ms. Macapella. Let me just get the old problem out of the way. My hearing letting me down now more and more. What is the name of this case that Sachs J gave judgment? Sounds to me like an obiter dictum, but I'd like to check for myself.
Quigliani.
Yes, of course. Got it. Please explain to me, maybe I'm just obtuse, but just please explain to me why comity matters, the principle of comity matters in matters where the merits play a role and not where procedure alone plays a role. I didn't understand that submission.
If I could answer the second question and then the Quigliani, I think you got the Quigliani question, Justice Majid.
No, Quigliani, I just wanted to get the name of the case.
Oh, I see. With regard to with regard to comity, when one has regard to what it is that the court seeks to certify, in the judgment of the magistrate judge in the US, there's a portion there where she states that it is not a hearing. It is purely, I think there's a portion where it says it is an executive, it's a judicial function. In other words, it's a tick box exercise in which the court in the requested state tries to look at the list of requirements that need to be present in order to certify an individual extraditable. And so she went through what those were. Now, and this is our submission, if the merits of a case in that matter were traversed, our contention is that the U.S. court would not have certified extradition because it would not have been satisfied that the documentation upon which it makes its case on point number 9, that is the prosecutor's affidavit, the investigating officer's affidavit, and the forensic report, if they had been privy to the information with false misrepresentations on the part of the prosecutors, then they would not have granted that they would not have granted that certification. But she could not do so in that court because all that the U.S. court looks at is whether those documents have been certified by the the central authority and whether they have been sent as documents that are in order by the requesting government. And so all it had to do, and this is what the judgment of Yefer J, although he found against Ms. Chalota, this is what the judgment said, that the U.S. court did not go and conduct its own exercise as to the validity or the truthfulness of the documents before it. It merely accepted that the documents were accurate and true. On the merits, if the merits were traversed, that would be something else because those facts and that evidence would have been led before that court.
Yeah, I don't like interrupting counsel, but you're repeating yourself. But what's all of this got to do with comity? Comity has got to do with the relations between states internationally.
Yes.
For them to respect their sovereignty, for them to have proper international relations, it comes into play in matters like these, but also in matters under the Rome Statute. That's where comity comes in. I don't understand distinction between procedure and merits when it comes to comity. And let me ask the second question, and perhaps it'll help. You make a great moment of the fact that the DPP said Mr. Nomaru is, Ms. Nomaru, I think her name is, she said that the department handles all these requests. It's simple what happens, and I'm going to go to the record now to read, because you've quoted selectively from the record. I'm going to ask that we read the whole part of the affidavit. It simply means this. The DPP has investigated the case. They formed a prima facie view that there is enough room here for a prosecution. They then, somebody does a memo, one of the officials, a prosecutor does a memo, say, we need to do an extradition request here. The DPP considers the memo. She says, yes, there's enough grounds for extradition. And that's what the affidavit says. The DPP then addresses that to DIRCO via the Department of Justice. Why? Because of comity. DIRCO handles international relations. So I don't understand this differentiation between merits and procedure. As I say, unless I'm obtuse, but what does it matter whether the magistrate there couldn't go into the merits? Comity is comity, whether it's just procedure confined or whether it also includes the merits. I don't understand that submission.
With respect, Justice Majid, it was not our submission. Our point on that was merely that we disagreed with the applicant and the fact that they base the principle of comity on the fact that they contend that the merits of the case were traversed in the United States and Ms. Charlotta could have challenged this, what she challenges in this court, in that court. And so our contention is simply that, no, that was not the case, as the prosecutor stated, that if she had issue with the merits of her case, there was nothing precluding her from challenging this in the whole.
You need not go further. Let's go to the record. Volume 6, page 589. Now, unfortunately, I have to do this at length because you say you seem to suggest there was a concession in the High Court that they don't handle extradition requests. They conceded that they don't have the power to make extradition requests, only the minister has. So let's look at this. Paragraph 15, Ms. Somaru, I said Ms. Nomaru, I apologize, Ms. Somaru said, the extradition process, while motivated for by the DPP, is handled by the Department of Justice and Constitutional Development and corresponding authorities. And it involves the following. The prosecution team draft memorandum, send it to the DPP. The DPP will support the request, deny or request more info. If supported, it's sent to another unit and so on, and it continues with the request. And that unit then engages further with designated officials within the Department of Justice and Constitutional Development in order to process the request. Officials within the Department of Justice then handle all engagements with the equivalent authorities in the requested state. And once the officials in the requested state are satisfied, I'm now at 15.6, their local lawyers proceed with the request to the legal system. And all of this is based on the fact that the extradition request is made, in fact, by the DPP, him or herself. So what's the point of the concession? Where in all of this is the concession that they've conceded in the High Court that it is the minister that makes this? Because it says in 15.5, the department handles all engagements. Isn't the extradition request one of the DPP? This is what this affidavit says. Okay, can you show me where in the affidavit it says, in terms, pertinently, that it is the minister alone who can make these requests? Because I understand the process to be the one that I've just explained to you.
Yes. At paragraph 14, Justice Majid, the paragraph preceding that, she states that she is the member of the executive responsible for facilitating extraditions under the Extradition Act.
What does the word facilitate mean?
In our interpretation, as in terms of this matter?
This case.
The word facilitating means ensuring that it is in line with the extradition treaty that has been entered into with another state.
You see, facilitate doesn't mean make in anybody's English. But let's go to section 179 of the Constitution, because I think this is what it means. It says in 179.2, the prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to instituting criminal proceedings. And then it says in 179.6, the cabinet member responsible for the administration of justice must exercise final responsibility over the prosecuting authority. It means that they must facilitate and they must ensure that there's supervision. Now, if you have a fugitive from justice, I don't know, for some other reason, child molesters like running to South Africa and Cape Town in particular. But let's say you have a fugitive from justice in the US. There is prima facie case here for a criminal prosecution, for whatever. You cannot prosecute under section 179.2 until that person is extradited here. Isn't that incidental necessarily to the criminal prosecution? Do you accept that it is?
I do accept that, Justice.
So how does the prosecuting authority not have that power, especially in light of paragraph 83 of Kaunda? I'd like to understand that.
Yes,
You
Justice
must
Majid.
please tell me quickly, Hani, I've found the case. Please tell me where in that judgment Sachs J says something different to what is said in paragraph 83 of Kaunda.
Yes. Justice Majid, our case was never that the NPA cannot exercise its constitutional obligations and request an individual that is in another state to be prosecuted in South Africa. That was never our case. Our case was that in this particular instance, the prosecutors had a deficient extradition request, and that was why it never came before the Minister of Justice. That is our case here. And to take it further, the submission is that the reason why it is important for the Minister to have that as 179 section 6 is the final responsibility is because it is the Minister that is enjoined in terms of international law as the executive member to bind South Africa, not prosecutors or a state organ. And so that is our case before this court. And that is what we say. In another instance, it can be different, but that is our case in this matter and why we say it was unlawful, that the NPA took this matter forward. It was the one that was liaising with the Department of Justice. It was the one that was carrying this to the exclusion of the minister, even when a judgment of the Supreme Court of Appeal stated that the minister had to be the one. That was our case. But I'm not... beyond that, I cannot.
No, I hear you. I'm careful about what I'm saying now, but there are all kinds of allegations. They are mere allegations, even before running commissions of inquiry, that members of the executive interfere in criminal prosecutions. Now here you have a DPP enjoined by the Constitution to prosecute without fear, favor, or prejudice. I'm postulating an hypothesis. I'm not saying this has happened or is happening. Purely hypothetically, you have here somebody to be extradited from the US because the DPP, prosecuting without fear, favor, or prejudice, thinks there's a prima facie case here to be prosecuted. Then submits a request to the Minister of Justice to do an extradition request. Now, on the hypothesis that there is this interference, the minister then can conceivably refuse on your understanding of the law. Am I right?
That is not our contention, Justice Majid. The minister cannot refuse unjustifiably and unconstitutionally. But where they are well within their rights in terms of the extradition treaty to state that what is contained in this extradition request offends this extradition treaty and results in South Africa offending international law, then the minister is well within her rights as an executive functionary to make that decision. But if it is a straightforward extradition request that does not contain any offensive or allegations that offend the extradition treaty, there's no reason that a minister exercising her duties constitutionally would not approve that. And so, of course, one can say that it might open up the door to use in a manner that is not intended, but for purposes of it being used in the way that the extradition treaty and the law has envisaged it, the minister would have no reason to do so unjustifiably.
Okay, now, I have a last question on a just and equitable remedy in terms of 172. But let me ask you about Kahunda. You know, I'm Afrikaans speaking. I'm an Afrikaans speaking, that's my mother language. But I thought that paragraph 83 in English is fairly clear. In terms of the concept of Kahunda, in terms of the Constitution, the prosecuting authority headed by the NDPP has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to the instituting of criminal proceedings. This would include applying for extradition where this is necessary. I thought I understood that English. You say I read it wrong.
You read it correctly, Justice Majid. You read it just as I did, but the contention that was made by the applicant is that it is the NPA that has the power to make extradition requests from other states. At all times in this iteration, it's talking about the extraditions, which, if one has regard to what Minister Lamula and the communication indicated, those requests are made or received by the Department of Justice. And so Kaunda is right. It is the NPA that has the power to make extradition requests, but that power does not extend beyond its station as a state organ and become an executive function, which is what requesting on the basis of requesting on behalf of a state would be to another state.
Now, just the last question. I think I'm taking up too much time, but you said earlier, I don't know if it was in the main argument or in answer to one of my questions, and maybe to my colleague Justice Mhlantla, that Lopsha J simply applied stare decisis. He applied Schultz. Schultz is not on appeal, and therefore this court is powerless. But surely that can't be so. If there's a glaring mistake of law, if the law was clearly wrong, and I'm just, again, this is hypothetically, I'm just putting to you a question. If the law is clearly wrongly applied, in other words, if Schultz was clearly wrongly decided, I said if, are you saying this court must live with Lopsha J's application of the stare decisis of a wrong decision and fold its arms and let all these extraditions go unchecked, and even this one in particular, even if it's not retrospective, simply because that matter is not on appeal? What about Section 172 of the Constitution?
Thank you, Justice Majid. In response to that, I wish to hearken back to our heads of argument where we delineate between what this case is about before this court and what this case is not about. This case is not an appeal on the merits of the Schultz decision. This court would be well within its rights to exercise that if that was the case.
Sorry, that's exactly the point. You keep saying that. But how do you compartmentalize, you say, there is a reliance on a judgment that was wrong, and therefore this court now is completely powerless in the face of Section 172, which this court has often said is an extraordinarily wide power that's afforded to courts?
I agree that it's an extraordinarily wide power, Justice Majid, but I do not agree that it is a power that can offend the rule of law. If a matter is not before a court, it has not been brought by the applicants by way on the papers, it would have been, as the case law said, unacceptable had it even done so afresh on appeal. But it did not even advance that position in the papers. It is precluded from doing so in the heads of argument. And it is not my understanding that Section 173 allows actions of this court that offend the rule of law. If a litigant has not brought a particular judgment on appeal before a court, that court cannot overturn that decision. This court cannot overturn Schultz, but further, it cannot find that Lopsha ought to not have considered himself bound by a valid and binding decision that was valid at the time and has yet to be overturned. And so the contention, it's my submission, Justice Majid, that would run counter to the interests of justice and the rule of law, the application of Section 173 in that manner.
I said it was the last question, but it's related, and my colleague on my right, on your left, it just reminded me about Mutsila. It's a judgment of this court recently given, where this court found pertinently, judgment which wasn't before the court of the SCA was wrong, and said so, and overruled it. It's not appealed against. Mutsila was a pension fund adjudicator. Perhaps if you're not ready for it yet now, you could perhaps ask for an opportunity later, but I want to raise this with you, that Mutsila is authority for the proposition that if a matter was clearly wrongly decided in an inferior court, and it comes into consideration in another matter before this court certainly has the power to overrule it, and it's done in Mutsila.
That would be Mutsila versus Municipal Gratuity Fund.
Yeah, I said pension fund adjudicator, it was a gratuity fund, because the pension fund adjudicator made a decision earlier on, yes. So you could have a look at it later, I mean, if you want to, but I just want to raise it with you, that there is authority for that. I have no further questions. Thank you, Ms. Mokapela, and thank you, BCJ.
Thank you, TCJ, Ms. Makape. If I said that the Minister of Justice is the accounting officer in the Justice Ministry, is that statement accurate?
Yes, that's accurate, Justice Chikwe.
Can it be compared then to what this court said in Kaunda in 83, that the minister bears the final responsibility?
Can the contention
Can the question that I posed to you and you said you agree with be equated what the court said, that the minister assumes the final responsibility?
in this instance, the accounting officer would be the official that is bound by the PFMA? Am I understanding the...
No, I'm simply comparing, I'm simply asking you, do you agree that the question I put to you about the accounting officer, about the accounting official,
Yes.
is it covered or is it similar to what this court said about the final responsibility? I'm asking if I compare the two statements, whether they are the same or not.
Then I take back my earlier concurrence, Justice Chikwe. I do not know.
Okay. So you don't know whether being an accounting officer is equal to assuming final responsibility?
In terms of 179, or in terms of Kaunda?
Well, I'm reading from Kaunda. I'm
Yes.
just asking these questions now without getting into the merits of this matter.
Yes.
Yes. I'm asking if the two statements are similar or they mean the same thing.
My learned junior says yes, Justice Chikwe. I'm going to have to go with my learned junior.
If that is so, I then don't understand why you would then say that it is the minister. Because what is before us is the order, the declaratory order that is in paragraph 2 or in item 2 of the order of the SCA. Because that order is very specific. It says that the national executive, it is the minister in his capacity as member of the national executive that has the power to make the extradition request. Is that accurate?
That is accurate, Justice Chikwe.
Even if that request was prepared by NPA, and
Yes.
even if the Constitution says that it is the NPA that has that responsibility.
To clarify that, Justice Chikwe, the NPA says that the Constitution says that the NPA has the power to make extradition requests. The Constitution does not say that the NPA has the power to make extradition requests from another state. And this order number 2 makes the clarification.
Sorry to interrupt you. You say that the Constitution says the NPA has got a right to make the request, extradition request, period.
No. If I may, Justice Chikwe. Kaunda states that the NPA, in its furtherance of its constitutional duties, this includes the right to make requests for extradition. That's what Kaunda says. Our clarification on that was that Kaunda does not say that the NPA, in having that constitutional duty, that duty extends to it having the power to make extradition requests from the United States. And that is what the Order 2 says of Schultz, that it is the minister that has the power to make extradition requests of the applicant from the United States of South Africa. So that international aspect of it is a function of the executive. That is what Schultz states, and that is what we align ourselves with. And that is what is indicated by the statement that is made by Mr. Lamula, that it is his office as the Minister of Justice that has that authority executively to make extradition requests from other states.
Is it not that it is the minister who has the final responsibility to liaise with officials in another country to make sure that the extradition request follows diplomatic considerations and all of that?
That is correct, Justice Chikwe. That is our case, and our case
How
is that
do we
that
then
is not
say
done.
that they've got the power to make the extradition request? Is it not the NPA that makes that request and then asks the minister to be a conduit, sort of?
When the request is received by the state that is being requested, it is a request, an extradition request from the government of South Africa. In that instance,
And we know that in South Africa, the power to make those requests and to prepare for them and motivate
Yes.
for them and to decide who to charge and who to extradite
yes.
rests in the NPA.
If I can,
Because I'm struggling to see how the
Yes.
minister would
Yes.
know whom to extradite and whom to charge.
yes, Justice Chikwe, we do not dismiss or disagree with the notion that the NPA has a duty in extraditions and that it has a role to play. Our contention and the finding in Schultz was that it has no such duty in relation to matters involving a requested state and international law. If one looks at the extradition request itself, at volume 1, Justice Chikwe, if I may.
Can I?
Yes.
Yes. Proceed.
Page 85 of the extradition request, the prosecutor is the one that makes assurances to the government of the United States. No prosecutor has such power. The prosecutor is the one that states that the rule of speciality will be observed, and I assure the government of the United States of America that Ms. Cholota will be prosecuted. No prosecutor has such executive authority to make assurances to another state. At the bottom, it states that the government of the United States can safely expect reciprocity.
Can I interrupt you? I've heard you.
Yes.
You've already explored this line of questioning with Justice Majid. It's just that I'm worried because even after that debate, I still have these concerns.
Yes.
Right. The question I'm asking is whether in response to me and in response to Judge Majid, you are not focusing on form rather than substance.
That I cannot, what I will say in response to that, Justice Chikwe, and I suppose to Justice Majid, is that I cannot say whether or not we are focusing on form or substance or on the wording, because I am not here on a Schultz appeal. And so if I was, perhaps these would be contentions that I would make and make knowledgeably. But that is not the question that I understand we are here to answer as respondents before this court.
Well, I hear what you're saying, but you said that Schultz is not before us. And I heard you when you said that. You said Schultz is not before us, and I disagree with you, and I sort of align myself with what was said by Justice Majid. But let me try and explain how I think order number 2 is relevant in this matter. Order number 2 is relevant in this matter, even if we are not dealing with Schultz. Because if we say that we agree with the SCA, then we would have to be agreeing with the SCA order in Schultz. Because we've got two judgments that say different things. Schultz says something else, and the Cholota matter says something else. So I'm asking you questions on Schultz because I want to understand, for my purposes, whether in fact the SCA was correct in Schultz or not.
The Schultz judgment, Justice Chikwe,
Judgment is relevant to Cholota.
Yes, Justice Chikwe. The Schultz judgment and the Cholota judgment say the exact same thing, Justice Chikwe, namely that it is the minister as the executive that has the power to make extradition requests from another state. That is what we are agreeing with. It is the NPA that is saying that it is the NPA that has that executive power and disagreeing with Schultz. But we are saying that we align ourselves with Schultz and that the judgment in the quota quo aligning itself with Schultz was correct and cannot be faulted.
Thank you for that correction.
Thank you.
We indeed say the same thing, which is why it is Schultz is relevant.
It is relevant, Justice Chiko, but it is not on appeal. It cannot be overturned by this court in this application. That was simply the point that we were getting at, that there's no application to
Is the
appeal.
reasoning in Schultz relevant, and can it be adopted this court if this court thinks that it is correct?
It is the reasoning of the quota quo in applying Schultz that is relevant. Schultz, which was valid at the time that the quota quo made the decision. It is the reasoning of Lobsha in applying Schultz, Justice Chiko, not the reasoning of the Supreme Court of Appeal in Schultz. That is our submission. Perhaps it is incorrect, but that is our submission.
This thing about misrepresentations from the South African side, how was it raised in the High Court? Was it raised as a special plea?
Yes, Justice Chikwe.
Was determined finally by the High Court?
It was not, Justice Chikwe. The decision of Lobsha was that there was no need to on the existence of this judgment from the Supreme Court of Appeal, because in any case, whether or not he made a pronouncement on that, the extradition was unlawful according to him, because it had been made by the NPA. The misrepresentations are contained in the special plea, yes.
If this matter went back to the High Court, would the High Court have to deal with the whole issue about misrepresentations?
Would it have to deal?
Would it have to deal with that issue?
Our submission is that it would not, Justice Chiko, because those misrepresentations are now common cause. The witnesses conceded to those misrepresentations, and I can take this court to those particular instances.
What I'm trying to find out from you is whether we should concern ourselves with those misrepresentations at this stage, because it seems to me that the question that is before us is basically about the person or the figure, the official figure, who has to make the extradition requests. And I'm asking this question because during your submissions, you spent a lot of time on those misrepresentations. And I'm asking myself how relevant they are to the matter at hand and how we should deal with them.
Thank you, Justice Chikwe. Our submission is that those issues are relevant when one considers the fact that that is the basis upon which the SCA held that it cannot be the NPA that makes these requests because of such considerations. That's why Justice Mabindla Bokwana made the point about undesirable consequences. These are the undesirable consequences. The acting Judge Yefer in the constitutional challenge held that indeed the NPA had contravened constitutional law and international law by placing these misrepresented facts before US officials. And so that is important for the interest of justice, because if we are concerned about the legality of extradition requests and the need to get fugitives back into the country for prosecution, it is imperative that those extradition requests be lawful, whether they are lawful in the way that they are made by the relevant functionary or they are lawful in the way that they are in line with the Constitution and constitutional prescripts. So our case is that the two go hand in hand. One cannot be concerned with the functionary in relation to a lawful extradition request on this side, and then the contents and the consequences of what it is when those extradition requests are made by not the relevant functionary. Our contention is that the two must go hand in hand on the basis of the interest of justice.
Well, I'm struggling to conclude that if the power vests with the minister, there would be no misrepresentations, because the minister would get that information from the functionary who performs that function. So if there are misrepresentations from the police or part of the investigating unit or the prosecutor or whoever, the minister would get that information, even if the request is from the NPA to the minister, as you argue. That information would be in that request and the minister would simply then carry it forward. So that's why I'm saying to you, the whole issue about misrepresentation, I'm not sure that it is relevant to who has the power to perform those functions.
I take the point, Justice Chikwe.
Okay, thank you, Mr. Chair.
Sorry. Ms. Makapela, in your uninterrupted address, you made the submission that the NPA must make the extradition request to the minister. Is that right?
That's correct.
Where do you find authority for that submission? Is it in the law? Is it in the Extradition Act? Is it in the treaty?
That would be in what we submitted yesterday, Justice Theron, which was the Minister of Justice, then Ronald Lamola, in September 2023.
I'm sorry to interrupt you.
Yes.
My question was, where in the legislation,
Yes.
is there any legislation that says that?
That says that?
It says that the NPA must make the extradition request to the minister.
Can I please ask for a rephrase of that question, Justice Theron? Where in the law do we find
Let me
the
start
position?
at the beginning. In your uninterrupted time, when you addressed the court, you submitted that the way the scheme works, the way the scheme of extradition works, is that the NPA must make or submit a extradition request to the minister. You recall making that?
Yes.
My question is, what is that submission based on? Is it based on the treaty between South Africa and the US? Is that where you get it from? Was that what supports that submission? Is it based on the Extradition Act? Because you were about to go to the document that evidences what happened in the Gupta matter. You see, the way an official behaves in a certain incident, in a particular instance, does not speak to how our legislation must be interpreted.
Yes.
Yes. So where in the law does it say, or impliedly say, that the NPA must make the extradition request to the minister?
The extradition treaty, Justice Theron, envisages that
Can you
the official...
refer me to the treaty, please?
I will. It is the minister that is signatory. I think it was in 1999 that the extradition was entered into the United States, and it was the Minister of Justice that was representing South Africa in that instance. The Extradition Act, in relation to all extraditions, envisages the minister. If I am reading, as explained to Justice Majid, if I'm reading Quigliani properly, what the legislation and the law does not show is that it is the NPA that has this executive function. And so it is obtained from a reading of the Constitution on the one hand, that a state functionary cannot exercise.
If it's not in the legislation that the NPA makes the request, and your submission, as I understand it now, is that the minister has the authority to make the request, can you refer me to any of those pieces of legislation that say that?
I think for the purposes of the direct reference, I'm going to say no, I cannot, Justice Theron. Because then Schultz would not have happened if it was that clear.
Yes. No, let's just leave Schultz. Let's try to understand what the law says.
Yes.
And that's what I'm trying to do. Now, Mr. Maduna signed the treaty. The then minister, Penel Maduna, signed the treaty between South Africa and the USA. And either below or above his signature, it says there, representing the government of South Africa. And the preamble, which I read out earlier, shows this is an agreement between two countries. And because it's an agreement between two countries, each country must be represented, properly represented in concluding that agreement. The fact that the then Minister of Justice was the designated representative of the government doesn't mean that that particular minister, as representative, in signing the document, assumes obligations under the treaty. Surely, whatever obligations must come from the treaty. The treaty must state what obligations there are, or powers.
I would have to disagree, Justice Theron, on the basis of 1796 of the Constitution,
It's 1796.
that the Minister of Justice assumes all responsibility over prosecution. If I can just, 1796, the cabinet member responsible for the administration of justice must exercise final responsibility over the prosecuting authority. And if we agree that it is the NPA that is tasked with combining the documentation necessary for an extradition, under 1796 and reading in the treaty, it is the Minister of Justice that would be the cabinet member that is responsible for that function. That is the interpretation that we submit, but it obviously does not need to be the correct one, but that is our position.
Yes. In your uninterrupted time, you also said that there are obligations on the minister in relation to extradition. What obligations rest on the minister under the treaty?
If I could refer Justice Theron to Volume 1, the extradition request by the prosecutor, Ms. Navila Somaru, page 85.
Ms. Makapela,
Yes, I'm getting to it.
I'm referring you to the treaty.
Yes.
What obligations rests on the minister in terms of the treaty?
Yes, Justice Chikwe, it is what is contained in I, under assurances. The Minister of Justice assures the requesting state that the prosecution or the punishment of a person is not for an offense of a political nature. They are obligated to make that assurance to a state. They make the assurance that the request or the prosecution is not made for the purpose of prosecuting, punishing, or otherwise causing prejudice to a person on account of a person's race, religion, nationality, or political opinion, and they assure the requesting state that that person has never been pardoned in another court.
Is that a prosecutor making the statement that you're reading from now?
But it is contained in the treaty. These assurances...
Please refer me to the treaty.
That would be
Remember what my question is. My question is, what obligations are there on the minister in relation to extradition under the treaty?
Just a second, please, Justice Theron.
Yes, for sure.
I'll have to ask my learned junior to find the treaty, Justice Theron, but I do recall that it was Articles 1 and 2 of the treaty which set out the obligations that each state assures the other state that they will do. One of them is that they will provide the accused person upon request, upon the provision of a valid, but it's Articles 1, 2, which...
Perhaps your junior can look for that while we continue. You also made the submission that the NPA must make application to the minister for the extradition. Is that right? The NPA must make application to the minister. Did you say that?
No, I did not say that, Justice Theron. It was that they should submit the request to the minister.
Okay. So the NPA must submit the application for extradition. I just want to understand what you're saying. The NPA must submit the application for extradition to the minister.
That is what they also state. That is what the DPP also stated, Justice Thoron.
Just want to understand what your position is
Yes.
and that of your client. Is it your submission that in the process of extradition, the NPA must submit a request or make an application to the Minister of Justice?
Our case is that the NPA submitted an unlawful extradition to United States authorities.
No,
And then our case is that we align ourselves with Schultz.
I'm really sorry to interrupt you. I'm not talking about what happened in this case.
Yes.
We're just trying to settle what the law is or what your submissions about the law are. Is it your submission that in the process of extradition, that the NPA must submit an application or a request for extradition to the minister?
That is correct, Justice.
What do you base that submission on?
On the fact that they do not have the executive authority to make that request.
Where in the legislation, in any of the pieces of legislation dealing with extradition, does it say that the NPA must make that request or application to the minister?
As I stated, Justice Thoron, I cannot find that in any legislation. What I was stating is that when one has an interpretation of the existing law and the Constitution, it is clear that the NPA is not clothed with executive authority to make extradition requests from other states, but the NPA is well within its constitutional obligations to make that request or to send that request to the minister as the executive.
When you say that the NPA is not clothed with executive authority to make that request, I'm not sure what you're saying.
To make that request from another government of another state. There's no state organ that has that authority.
If we look at the treaty between the US and the USA, who or what does that treaty clothe with this executive authority that you're referring to?
That would be the cabinet minister responsible for justice.
Can you refer me to the treaty where it says that, please?
That is the signatory. By virtue of the minister being signatory to the treaty, that is the individual or that is the office that is clothed with that authority.
Is there any provision in the treaty that says that?
That says it is the minister that is responsible for making extradition requests.
Yes.
I'm not given to understand that there is such a provision, Justice Thoron.
Now, what if the government had designated a Director General of Land Affairs, for example, to represent the government in concluding this treaty, and that person's signature was on this document? Would it then follow that the Director General of Land Affairs then has to give permission or must make the application?
I cannot say.
That's your argument taken to its logical end, that the person who signs on behalf of the government then becomes personally responsible or has that power.
It is not my argument, Justice Thoron, with respect that a functionary that does not have, that is not clothed with the function that it is being requested to do, so Land Affairs Director General taking the place of a cabinet minister, that is not
That's why
our
I asked
submission.
you the question. Where in this treaty do we get it from that the minister is clothed with executive authority, to use your phrase?
That is what I said. I cannot answer to Justice Thoron, that there is no such provision in the treaty that I am aware of. That position is
Then how
gleaned
can we accept that submission?
because it is an interpretation of the extradition treaty, the Constitution, and the Extradition Act. And the fact that none of those documents contain the NPA as the functionary. It is an interpretation constitutionally of the import of that of those pieces of legislation. It is not to say that it is contained therein. It is to say that taken together, it can only be the member of the executive that is clothed with that function, and it cannot be a state organ.
Yes. Let's move on to another aspect. You referred this court to a document that evidenced that the previous minister, Mr. Lamola, had been involved at some level with the extradition of the Guptas. What was the purpose of referring the court to that? What can we extract from that? Apart from, in that instance, the minister played a role. Do we know what role exactly the minister played? Do we know that the request for extradition was made by the minister and not the NPA? What is the value of that document?
The value, Justice Theron, was in response to a submission being made or a position being taken for the first time in the heads of argument by the DPP that the NPA, had the authority to make extradition requests. In the papers, the NPA stated that it has always been, up until Schultz, it had always been the state organ that dealt with extradition requests. The provision of that document was to show that that is not correct, together with the provision of the DPP's position, that they themselves, on their own evidence and what the minister has said.
So I understand you to say then that that document shows that the argument presented by the NPA is not correct.
That is correct.
Where does that take us?
That takes us to...
We still have to interpret legislation.
Yes. That takes us to the following position, Justice Theron, that no matter what the NPA says in relation to it having the power to make extradition requests from other states, that is incongruent with the Constitution and the legislation in that it is still not the executive. That is an executive function, that facilitation of extradition requests between states. Not so much the power to submit documentation in relation to the desire to prosecute an individual, insofar as it is the prosecution that is making assurances to governments across the world that they can assure that these have been followed, that they can assure that extradition obligations have been satisfied. There's no prosecuting authority that has such power. It is on that basis.
I know my sister Justice Chikli took you to the order of the SCA. Can we look at that again, please? It's at page 208, volume 2 of 6. Paragraph 2 of the order. Are you there, or have I given you incorrect?
Volume 2?
I'm sorry, I've actually referred you to the Schultz bundle.
Oh.
Do you have the order of the SCA in front of you?
I do, Justice Theron.
Paragraph 2 of that order says, it is declared that only the first respondent in his capacity as a member of the National Executive has the power to make an extradition request for the extradition of the applicant. Do you agree with that?
I do not agree that because it states from the United States of America.
Yes.
So I agree with it when it states that it is the power that has. I agree with the full interpretation of the order, that it is the member of the executive that has the power to make extradition requests from the United States of America.
And would you agree then that the NPA does not have the power to make extradition requests?
No, Justice Theron. I would submit that the NPA does not have the power to make extradition requests from the United States of America.
From which country can they make extradition?
From no country. They are not an executive functionary.
That's what I'm asking you.
Yes.
So you agree that the NPA does not have the power to make extradition requests?
They can submit extradition
to
requests.
somebody outside the country.
Yes, they can submit extradition requests to the minister, but it is not our submission that they have the power to make extradition requests from any country.
Under which legislation do they get the power to submit the request to the minister?
Under the Constitution, under their duties under the Constitution.
Please refer me to that.
179, subsection 2.
Where does it say in subsection 2 that in exercising the power given to them by the Constitution in terms of that very section, they have to seek approval of the minister or work through the minister in any way?
That would be under subsection 6, that the minister
Question,
must exercise.
Ms. Makapela, where in section 1792 does it say that that power is subject to any authority from the minister?
That would be in 1796, Justice Theron. My answer remains because it states there that the minister, the cabinet member, must exercise final responsibility over the prosecuting authority. So that would be over the entire prosecuting
What does
authority.
final responsibility mean?
In this instance, it would be the facilitation of an extradition request.
What would final responsibility mean where the NPA decides to prosecute a local person? What role would the minister play?
That has different considerations.
We are dealing with the same section. We're dealing with section 1792.
Yes.
We have to interpret what that section means in all different scenarios.
Yes.
So what does that section mean? Does it mean the minister has the final say? I'm getting to that age where I need my glasses. When the prosecuting authority exercises power to institute criminal proceedings, doesn't say within South Africa, out of South Africa.
If
just says the NPA has the prosecuting authority has the power to institute criminal proceedings. Now, your argument, taking to its logical end, means that the minister has a say in prosecutions locally and in extraditions.
No, that is not my argument taken to its end, Justice Theron. Our argument is in relation to extraditions under international law and in relation to extradition treaties. The prosecutions in this country are not subject to that.
See what my difficulty is? 1792 does not limit the NPA's authority and does not say that that authority is vested only in respect of prosecutions in South Africa.
That is correct, Justice Theron, but it does not clothe it with executive authority either.
Yes. Thank you, Ms. Makapela. Thank you, Deputy Chief Justice.
Factually. Ms. Makapela, can you please explain this to me and clarify to me and remind me? In this matter, in this Ms. Cholota matter, after the NPA had drafted the extradition request, was it sent to the minister or was it sent directly to the US? Factually, in this matter, what happened practically? Was it sent directly to the US?
That was the bone of contention in the court of quo, Justice Chickley. They did not advance any such facts or evidence before the court of quo, so we do not know. But what their witnesses told us was that they did not know what happened with the extradition request or who made it and when it was made. That was the evidence that was before the court of quo. And so I cannot answer to that because the prosecution never led any evidence in relation to that. But what the documentation shows is that there is no document where the Minister of Justice approved or signed or ratified or indicated any involvement in this. And in the application before this court, they state that this is common cause. If I can just take...
You state it is common cause that it was never considered by the minister.
That it was not made by the minister, yes, that's correct.
I'm saying... Not that it was made by the minister. I'm saying after the NPA prepared that request for extradition, did it send it to a member of the executive before it went outside to the US authorities?
That would have to be Mr. Trengo's submissions, Justice Chikwi. That is what we were trying to get out of the witnesses as well, in trying to look at the legality of the extradition request.
Okay, thank you. Thanks.
Ms. Makapela, following on the question by Chick, I still have my questions. Now, so where does that put us? If we all don't know whether the NPA sent it via the minister or sent it directly or via the minister, does it have any bearing at all on how the processes was sent to the US authorities? Or is it a condition precedent that it must go to the United States via the minister? Remember, the treaty is silent,
Yes.
so how did it get there?
Justice Matopo, thank you for that. I will answer it as I've been answering perhaps every other question, that we with Ms. Chalota are here in relation to the overturning of the decision of the Court of Code that applied Schultz. The Schultz judgment is still valid and binding and has not been overturned. And so this court cannot overturn the judgment in Schultz, nor can it find that the Court of Quo was wrong in law when it applied a valid and binding decision. That the NPA now comes to this court in the heads of argument, claiming that Schultz was wrongly decided, is a matter for this court to make a pronouncement on, but only insofar as, can a litigant do that? Can a litigant bring a new issue on the heads of argument that was never advanced in the papers? The cases are replete saying no. So that is our case, that the determination on Schultz cannot happen in this matter.
But if you were to characterize the narrow issue before us, is the issue not whether the NPA or the minister has the authority to make the request for extradition?
No, Justice Matopo,
So
with respect, the issue before us is, was the Court of Quo correct in the decision that it came to, namely that the extradition was unlawful? In coming to that decision, it applied Schultz, which was a valid and binding decision that says that it is the minister that has the executive authority to make requests from the United States, not the NPA. The Court of Quo applied that. The narrow decision, the narrow issue for determination in this court is not this new issue that was raised in the heads of argument. It is whether or not this court can exercise its discretion to overturn a decision of a Court of Quo which rightly applied the law and followed an order of a court, being the Supreme Court of Appeal. That's the narrow issue before this court. It's not whether or not it's the minister or the NPA.
Let's take a step backwards and look at the judgments of the High Court. What is it that the High Court said about the authority that is vested or not vested on the NPA or not, or the minister? Did it say anything?
This would be the High Court of Quo.
Yeah, the Lobsher's judgment.
Yes.
Did it say anything on that?
Yes, it said the extradition was lawful for want of a valid extradition request. The extradition request was not valid because it was made by the NPA.
Yes, but that is now the issue before us.
Yes.
The issue before us is whether the High Court was correct in holding that the request was made by the NPA or not the NPA. It's that not the issue.
I beg to differ on this very nuanced point, Justice Matopo, which is why we made that delineation in our heads. The issue is whether that judge sitting in that court with the evidence that was before him came to the correct decision. Part of the decision he came to was to apply a decision of the Supreme Court of Appeal.
But you and I know,
Yes.
when we read the judgment, nothing is said about the other grounds that you raised. The only ground that he said I did not deal with them.
Yes.
I can only deal with the Schultz matter. That's what he said.
Yes,
And
that
he
is
considered
correct.
himself bound by it. And that was the right decision on his part to say that.
Yes.
Whether it is correct now, it's open to some question.
But is that correct, though, to question after a high court has come to a decision validly, whether now on new aspects that advanced in the appeal court for the first time whether that decision applied was wrong, when that decision is still valid and binding. Because even if this court came to the decision that Schultz was wrongly decided, that does not overturn Schultz. Schultz remains valid and binding because there is no appeal before this court appealing Schultz. And so it will create the undesirable consequence, to borrow from Mabindla Bogwana, the undesirable consequence that there's a judgment here that is not an appeal on Schultz.
But
there's a valid judgment from...
The legal issue that has to be determined here is whether the NPA or the minister has the authority to make the extradition request.
We beg to differ, Justice Matopa. That is not
So what are we all about?
the quota quo, the decision of the quota quo, and whether that judge exercised his discretion validly. That was a criminal matter.
No, wait. You're talking about the discretion now. But the judgment does not talk about his exercise of a discretion. What is it that he said specifically that I am now looking at the facts, and then we can find that whether he exercised a true discretion or a wide discretion? Is there on the case, on the judgment itself?
That's correct, Justice Matopo, on that fact, but we will not agree that what the question is before this court is the question on the merits in Schultz. We will, sadly, we just will not.
What is, now that's where you're confusing me.
Yes.
I've listened to what was put before us about the issue being the authority of the NPA, the second issue being the US court, the third issue being the Ibrahim principle, your Audi and the Schultz, which are right at the back. But the main issue, according to the applicant, is whether the High Court correctly applied the law in terms of Section 179(2).
Yes, that I agree with. That is the question. But the question is not whether the NPA is the one that has the executive authority or the authority to make requests.
If the question is answered in the affirmative, that on a proper interpretation and reading of Section 179(2), the authority vests with the NPA, and borrowing also from Kahunda in paragraph 83, and the authority now is buttressed as vesting in the NPA, then if we are to say, yes, that is how the court ought to have dealt with it, then this court would then indirectly be saying, Schultz is wrong.
Yes, that's correct. And this court would be committing a grave miscarriage of justice, Justice Matopo, because the respondent, that is not the case that the respondent was invited to answer. That is grossly prejudicial to the respondent.
But let's take it again a step backwards. The Schultz judgment, absent any pronouncement from this court, would remain binding on all the lower courts, perhaps with us if we have not said anything. But now we have an opportunity to have a look at the Schultz judgment. If we disagree with the finding of the Schultz judgment, we will make a pronouncement to say, on the facts of this case, this is the legal issue that we have been invited to debate and adjudicate upon. We have debated that issue, and if we find in the positive, then Schultz will fall flat. But if we find in negative, Schultz will prevail. Is that not what we are required to do?
Justice Matopo, as a junior, I cannot speak to what this great court can do. Only what my instructions have been in this case, which is to remind this court what this application that has been brought by the NPA, not by us, is about. If the issues now move from what they were presented originally, that is counter to the rule of law and the interest of justice. It has, because it turns into an appeal on the merits of Schultz, which is not what is before this court.
Nothing has moved.
But the merits of Schultz are being debated right now in this court as though it was an appeal.
When you have an opportunity later in reply, have a look at Mutsila in this.
Yes.
Probably you would have a different approach after reading it. Maybe Orlando Jr. can look at it.
It is before me now, Justice Matopo, but if, perhaps I can be corrected, but if I understood Mozilla correctly,
But you haven't considered it.
Yes.
I don't want to be unfair to you.
okay, then I will consider it, but
Yeah,
I
want
do have
to-
thoughts.
Yeah, have a look at it.
Okay.
But let's cut all the frills and look at what this case is all about. A judgment that would say the issue or at the heart of this issue is the question whether the NPA is vested with the authority to make the extradition or not. That is the issue, as I understand it. The other issues about the distortions, the misrepresentations, the alleged lies or the lies, they whittle down to that little issue that we have to determine. Is that not so?
I can take it no further,
Also,
Justice
because
Matopo, I
there's
cannot
nothing,
agree.
there's nothing from the judgment of the High Court that invites us to interrogate those issues.
That is not my understanding of the issue that is before this court, Justice Matopo, and I can take it no further.
Further, no?
No.
Thank you.
Makapela, I thought we will finish with you and then get the reply, but looks like there's a lot of interest. So I'm going to adjourn for 30 minutes, and then we'll come back. You will
Still with me, Chief Justice, still with me. Oh, okay.
Still me.
As the court please.
Well, I had hoped to not prolong your presence there, but looks like, as I said, there's interest in putting questions to you. So we're going to adjourn for 30 minutes, and then you'll face questions from Justice Kolapen and Justice Nichols. Thank you. Court adjourns.
The request, supporting documents and subsequent communications shall be transmitted through the diplomatic channel directly between ministries of justice or any other authority designated by the state parties. We have ratified this in 2006. What do you make of it? I was actually going to direct it to Mr. Trengrove, but I thought I might as well canvass it with you.
What do I make of that provision
Yes,
in the
does it
SADC
support your
protocol?
argument in a way or not? Or is it a question of there must be, there's obviously now conflict depending on what we would decide. If we say for the SADC countries, the 14 SADC countries who are signatories here too, there must be a special dispensation that the request is made by the NPA, but country to country, it is done by the ministries, respective ministries, as you initially argued. And then for all other countries, it is different. It is only the NPA. Or what do you say?
I agree with the first portion of the question, Justice Musi, that it is the designated official and also the minister. I agree with that. And South African law, if we are to understand it as it currently is, and that the SCA judgment is binding, means that the NPA is not the designated official if the judgment is read in its current form, that the executive is the functionary. And if I may just add to that, and in response to the earlier question by Justice Thuran as to the relevant provisions in the treaty, my learned junior, once again, thank you, Mr. Mbeki, has located the treaty, but it is not part of the record. However, the relevant aspects are Article 2, as I stated, at page 3, which provides for the executive authority of the requested state. And then Article 4 at paragraph 3, also the extradition shall not be granted if the executive authority of the requested state determines that there are substantial grounds for believing, and then it goes on. But everywhere in the extradition treaty, it is envisaged that it is the executive authority of the requested state that is to be, or rather if this is the treaty between the United States and South Africa, it is the executive authorities of those respective countries that are tasked with handling extraditions per each other, the requested state. And so the protocol would then be in line.
That relates to incoming requests.
No. The extradition treaty is per each country, from country to country, extradition and incoming and outgoing, Justice.
Where does it relate to when we request the extradition of someone?
It relates.
Does Article 2 assist?
Yes. So it's the extradition treaty between the government of the United States and the government of the Republic of South Africa, and that noting that both the government of the United States of America and the government of the Republic of South Africa currently apply the terms of that treaty. And so if in a particular instance it is the United States that is requesting, it is the executive authority of the requesting state. If it is South Africa that is requesting, it is the executive authority of South Africa. So it is the executive authority of whatever country between the two countries is doing the requesting and the provision, if the extradition treaty is read in its current form and interpreted correctly. But the point that I'm making is that it speaks to the protocol that you have asked me about, because it also envisages executive authority.
But executive authority is not defined in that treaty, not so.
No, it is not, Justice Musi.
Thank you.
Thank you, Ms. Makapela.
Oh, just one final thing,
It may
Deputy
invite
Chief
more
Justice.
questions. It may invite more questions, but what?
No. I was asked by Justice Majid on Liani and the particular provision that was relevant. That would be, and I suppose it's in response to all the other questions, paragraph 43, The Act, read with other legislation, such as the Criminal Procedure Act, thus gives the executive branch all the required statutory powers to be able to respond to a request for extradition from a foreign state, and for the executive branch to be able to request the extradition of individuals who are in foreign states. It should be added that although the power to request extradition to the Republic from a foreign country is not expressly provided for in the Act, it is necessarily implicit in sections 19 and 20, and both deal with requests for surrender. And indeed, section 19 expressly envisages extraditions being requested in terms of the extradition treaty. And so I think my answer was that upon an interpretation and a reading of the treaty together with the Act and the so-called established what we termed was the established practice that was indicated by Minister Lamola, all those taken together lead us to the conclusion that it is the minister as the executive that has the executive authority to request from another state. Thank you.
Can I ask
Thank you,
something, DCJ, please? As you have said to Council, she's been forewarned. Do you accept that that is obiter dictum? Because this case concerned whether the president, whether the minister had the power to sign this extradition treaty between the US and South Africa at the time. So this is obiter dictum as far as this case is concerned. Do you accept that?
I don't have a particular answer, Justice Majid. I do not have a particular answer to that, but my learned colleague, Mr. Katz, indicated that he has thoughts about that, yes.
I mean, no disrespect, but he usually does.
Thank you, Justices.
Thank you, Ms. Makapela.
Sorry, I see.
May it please the court.
Please, thank you.
Forgive me if I do this rather rapidly. My learned friend seems to accept that the Constitution vests a power in the NPA to make requests for extradition. She accepts the accuracy and the validity of this court's finding in Kaunda that power, the prosecutorial power, includes a power to apply for extradition. But she says that means merely applied to the minister, not applied to the foreign country. But with the greatest of respect, that completely hollows out that those provisions, the constitutional provision and this court's dictum in Kaunda, to say that you have the power to apply for extradition doesn't mean you may ask the minister whether you may. It means that you may make such an application. So with the greatest of respect, having not challenged the proper interpretation of the Constitution, the express finding in Kaunda, it is not open to Ms. Charlotta to argue that the power to apply for extradition means merely a power to apply to the minister for permission to seek extradition. She reads this qualification or finds this qualification in section 179(6) of the Constitution. Now remember, the context is after having entrenched the NPA's prerogative to conduct prosecutions and everything incidental to it. Subsection 6 says, the cabinet minister responsible for the administration of justice must exercise final responsibility over the prosecuting authority. We submit with respect that provision can't be read to hollow out everything that's been said before. It simply means final responsibility means administrative responsibility, not an assumption by the minister of the powers expressly vested in the NPA. And there was, in fact, that provision was modeled on a Namibian case. I forget the name of the Namibian case, but it was something like Prosecutor General versus Attorney General, precisely about that division of power and whether it is permissible to make a political member of the executive responsible for the prosecutorial function. And the Namibian court held that it was because that function of the minister is interpreted merely as an administrative function and not a power to meddle with the exercise by the prosecuting authorities of their power to prosecute, which includes the power to seek extradition. Our learned friend says that the treaty speaks or attributes functions to the executive authority. I've not been able to check the whole treaty again, but the article to which she referred was Article 12. And Article 12 does speak of the executive authority again and again and again, but in the context, clearly speaking of the executive authority of the receiving state that deals with a state that receives an extradition request. The executive authority deals with that request. In South Africa, we have such an institution controlled by the Department of Justice to handle incoming requests. But this reference to the treaty doesn't lend any support to the proposition that the power to make outgoing requests for extradition vests in the executive. Our learned friend said that the point, the Kaunda point, sorry, not the Kaunda point, the Schultz point, was made early on in the hearing, in the trial within a trial before the High Court. And for that proposition, she refers to the fact that the Schultz judgment was handed up. But with the greatest of respect, her interpretation is quite mistaken. The Schultz judgment was handed up. You'll find the record of that handing up at page 1158 to 1159. But it was handed up not by my learned friend for Ms. Charlotta. It was handed up by counsel for another accused, Mr. Magashula. And he didn't explain what point he sought to make by handing up this judgment. So the judgment was handed up. Ms. Charlotta's counsel did not make anything of it. Nobody else explained its significance, and it was certainly irrelevant to the special plea that was before the court at that point, which raised the 4 points and no other. And while I deal with that, my learned friend now gives a broader interpretation to the special plea. But with respect, the interpretation is not correct. The special plea is at page 2128 of the record. It raises, and remember, this is a special plea filed in terms of a section which requires the accused to specify the grounds upon which the court's jurisdiction is challenged. The special plea complied with that requirement. It listed the grounds in paragraphs 4.1 through to 4.4. My learned friend says that it broadened those grounds in paragraph 7. But paragraph 7 was merely a conclusion. It didn't raise any new grounds at all. It said, the extradition of accused 17, Ms. Charlotta, is unlawful. As such, this court is precluded from trying the offences she is charged with, as the unlawfulness of the extradition renders the jurisdiction of the South African Criminal Court void. It is obviously a conclusion based on the 4 grounds already articulated. There is lastly the question of how to deal with the impact of the Schultz judgment on the Charlotta case. We submit with respect, Justice Matopo's analysis was correct. It is commonplace that an appeal comes to this court on a matter on which there is an SCA precedent. And the High Court may well have followed the SCA precedent because it was bound to do so. But if the case then comes before this court, this court is not bound by the precedent. It simply considers whether the SCA precedent is right or wrong, and it either follows it or it does not. But it doesn't introduce any other complicating feature, because the other case, in this case the Schultz case, is a separate case, the high water mark of which is that there is a final judgment of the SCA upholding the Schultz, upholding the point that the request for extradition must be made by the minister. But that is not a jurisprudential hurdle any more than a precedent, an SCA precedent, which was correctly followed by the High Court because it was bound by it, which now comes before this court, which is at large whether to adopt the same conclusion as the SCA judgment or to depart from it. Thank you very much, Deputy Chief Justice.
Thank you, DCJ. Mr. Trengrove, I discussed the SADC protocol on extraditions, and it seems to me that in that protocol, there is a distinction between making the request and then the minister comes in, then it's a ministerial, Minister of Justice to Minister of Justice, or somebody assigned by the state.
Yeah.
It seems to me that it's not an absolute thing that the Minister of Justice is never involved in facilitating between the two states.
Yeah. Now, with respect, Justice Musi, let me confess, I didn't study the protocol. But the protocol is, of course, not the Constitution. And the protocol must be interpreted in compliance with the Constitution. And if it is capable of an interpretation, as you suggest, that means that the decision is taken by the NPA, the facilitation is done by the minister, then that would be perfectly compatible with the Constitution. But the moment it makes the NPA's decision to prosecute, and therefore the decision to seek extradition, subject to permission of the minister, then it offends Section 179.
Thank you, Mr. Trengrove.
Thank you, Deputy Chief.
Thank you. Mr. Hopkins, I think it's your turn. Right. Mr. Hopkins.
Thank you very much,
This
Deputy.
is for you and Mr. Katz. I mean, in the Cholota matter, we had full argument on everything, including merits.
Yes.
In this part of the hearing, it's on a restricted basis that we're going ahead. I'm talking about the time allocation. I know what I said in the morning, but just keep in mind what I'm saying now.
Will do.
Thank you.
Thank you. So perhaps I can just start by reminding the court that the Schultz order was handed down on 23 May. We find that on page 228. Now, we've switched records, obviously. What that does is it says only the Minister of Justice has the power to make an extradition request for Mr. Schultz from the US. So our learned friends have quite a lot to say about what the declarator means, and effectively they say two things. They say, number one, it's unique to Mr. Schultz, it applies specifically to him only, and number two, they say it operates prospectively only. Now, so that's the starting point of what they say, and that's what they say in this court. But that isn't entirely consistent with what they've said all along. But it may not necessarily matter, because when it comes to interpreting court orders, what we've got is we used to have the old Firestone approach. If there's a citation that's needed, I can provide it. But in the old Firestone approach, of course, the idea was always that the order is the executive part of the judgment, and that you only get to look at the reasoning of the court if that particular executive order is ambiguous in some way. But then we know that after this, we've got HLB International, that's an SCA judgment in 2022, and that changes things. And it applies roughly the same principles that apply with interpreting everything, and that is the unitary approach. And so in paragraph 25, for example, of HLB, the SCA emphasizes that Firestone is no longer the law. In paragraph 26, it now says the unitary approach is the law, and the unitary approach means you look at the order and you look at the reasons. And the reason that I mention all of this is only because when you look at the reasoning of the SCA, there can be very little doubt that it applies to every outgoing extradition request, not just the one for Mr. Schultz and not just the one to America either. It applies to all of them. So that is fairly significant. It's fairly significant for the following reason. It's significant because if it doesn't apply very specifically to Mr. Schultz, then it must apply generally to all outgoing extradition requests. That is why retrospectivity is important. Because if it applies generally to everybody, then the default position, of course, is that it's a declarator of law, not a declaration of Mr. Schultz's unique situation, but a declarator of law applicable to everybody. And in that instance, then, the default position, it applies with full retrospective effect unless tempered. So that's why we're here, to temper the retrospectivity. Now, having said all of that, the NPA's application for leave to appeal, we found that in volume 3, it's on page 231. And that application, as we know, was instituted, unfortunately, 3.5 months late. That's 3.5 months outside the 15-day period in Rule 19. However, in the application for condonation, the reasons are given from paragraph 75 to 119 of that particular founding affidavit. And those are fairly comprehensive reasons. And I know that we're on limited time here, so I won't go through the condonation application and the reasons. Safe to say that there are broadly 3 reasons why we were late. The very first one is that there were national elections at the time. Because there were national elections at the time, the Department of Justice wasn't functioning as it should. In fact, there wasn't a minister and there wasn't even a deputy minister of justice. It became very difficult for the parties to consult with one another. Then we had a GNU after that. And the situation in the GNU again made it very difficult for the NPA to consult with the Department of Justice to decide who was going to bring the appeal. And then finally, much is said in the condonation application about the state attorney's briefing policy and how that policy hamstrung the NPA's ability to get legal representation. And that also delayed and frustrated matters. So without going into more, if I could refer you, please, to those paragraphs, and of course I'll address questions if there are any, but that's where condonation is set out. So where we are then is we have an application for leave to appeal to this court, and it's been instituted a little later than it should have been, but that application, importantly, attacks both the merits of Schultz and, of course, it deals with retrospectivity if we don't come right on the merits. And that was the application. I'm not going to go into the merits of Schultz and why we say it was wrong, because the reasons are fairly similar to those that have been advanced by Mr. Trengove. And you'll find that the full argument is in fact set out in our application. That hasn't been abandoned in the notice of motion, but what did happen is the National Director sought to withdraw the appeal and then reinstate it, obviously on the limited grounds of retrospectivity. And her affidavit we find in volume 4 on page 353. And that's where she gives her explanation for doing so. But the point that I want to emphasize here is that at no point did the National Director concede that the SCA was right. You won't find that concession. In fact, what she does say is she does say, well, even if the SCA was wrong, I still don't want to appeal the order, and the reason is because I believe I can work it out with the Minister of Justice. So in other words, there was the settlement of a dispute between the National Director and the Minister of Justice. That took place outside of the process. And obviously one can, for a number of reasons, one can elect not to challenge a court decision. It doesn't necessarily mean that you accept that the decision is correct. There might be other reasons, and here there was another reason. The reason here was because it was felt that the two parties could sensibly resolve matters. Whether or not they can is an open question, I suppose. I'm not sure whether two functionaries can, for example, resolve a rule of law issue. But that is there, and the instructions that I was given was then to argue the retrospectivity point. And in the context of everything that's been said today, it seems to me as though the argument only becomes relevant if you don't accept Mr. Trengove's authority point. If you accept that the NPA does have the authority, then nothing I have to say about retrospectivity matters. Having said all of that, there are a few things that are necessary for me to say. And these are questions about retrospectivity. So you'll find a section in the heads of argument, and these deal with the problem of retrospectivity. And this is where the application comes in to admit new evidence. Now, it's not strictly new evidence in the sense that it was something unforeseen. In the original founding affidavit for the application for leave to appeal, we find that, as I said, in volume 3 on page 231, there are a number of paragraphs, 9 of them, paragraphs 38 to 47, that deal with foreseeable problems. In other words, these are things that the NPA could foresee would become problematic if the retrospectivity of the SCA's judgment wasn't tempered. So there's a description of the 89 outgoing requests that were issued by the NPA. There's a discussion how each one of them might be in jeopardy. There was some time spent on these applications, if they are vulnerable to being set aside one by one, how each of them, because they're the product of hundreds, sometimes some of them thousands of hours of work, a lot of effort, a lot of costs, will set back the NPA in its fight against crime. And of course, the reputation of the country will suffer, the criminal justice system will be impeded from operating properly, and the administration of justice will be harmed. So all of that is dealt with in the founding affidavit. A few examples are given. The most prominent one is the case of Richard Payne. And in Richard Payne, just to illustrate the point early on, it was described how Payne fled South Africa. He went to Mauritius. From Mauritius, he fled to the UK. The law caught up with him. 10 years of preparation had gone into the preparation of the case against him. There are 200 lever arch files of evidence. A lot of it is forensic work, expert evidence. The big trial is coming up now next year, and that matter had been challenged. both in Pretoria and in London, and both of them based purely on Schultz, for no other reason. So even if Mr. Schultz's argument is correct that the SEA's declarator only applies to him, well, that's not what's happening in real life. Because in real life, we can see the Pretoria High Court saying, no, Schultz is binding on us in relation to Mr. Payne. We can see the Free State High Court saying, no, Mr. Schultz is binding on us in relation to Ms. Chalotta. So it is having these ramifications. There's the intervention application, which you dismissed earlier, prior to the hearing, of Caro and Perez. Those are the two guys that were being sought in Spain. Exactly the same thing. They had an 8-page founding affidavit. And that 8-page affidavit was again based squarely on Schultz, saying, well, you can't request my extradition if you're the NPA, because only the Minister of Justice can do that. So these are issues that travel way beyond Mr. Schultz. And the problems, if you're not with Mr. Trengove on the authority point, then retrospectivity becomes an absolute necessity. One has to temper the retrospective effect. In the founding affidavit, the domino effect was spoken about, how these things keep on unraveling. So the application to admit new evidence came several months later. And that was just really to provide the court with evidence to say the problems that we anticipated would happen are happening. Things are unraveling. The domino effect is taking place. And for that, we had to place all the evidence before this court, and we did that in an affidavit. Of course, the evidence in the application for leave to appeal of itself is new evidence, because it's not in the record that's served before the SEA. So the application to admit this new evidence is there to assist the court. And we also respectfully submit that it meets the requirements in the rail commuter's case. In other words, it's weighty, it's to be believed, and there's an explanation for why it wasn't there before. It comes afterwards to assist the court in understanding how these problems are unfolding. And so there you've got all the subsequent cases. Payne is dealt with, the developments after the application went in. Ms. Chalotta's matter is there. Then the Mandi brothers are there. Elia Mokotwana is there, same with Caro and Perez. So all the evidence is placed before this court to show how devastating it will be if one by one these matters unravel because the wrong functionary made the request. Now, perhaps I'll come back to the correctness of the SEA's judgment a little bit later. I'm not mandated necessarily to argue that, but Justice Theron, you had a few questions for Mr. Trengove. And Mr. Trengove, because these issues weren't part of his record, they're part of ours, it may just be useful if I were to direct you to places where you can look for the answers to your questions. Your first question, you wanted to know what the role of the Minister of Justice was in extraditions. The second is you wanted to know what the role of DIRCO was. And the third is you wanted to know if there are any other authorities around the world where extradition requests are made by prosecuting authorities as opposed to by executive authorities. The answers to those you can find in our founding papers, because that was our case before the NDPP clawed it back. So, for example, the role of the Minister of Justice, she or he plays absolutely no role. There's a role that's played by the Department of Justice, but not by the Minister of Justice. And the Department of Justice's role is explained in the founding affidavit that served before the High Court. And there, the role of the Department of Justice is a conduit. So the NPA, as part of its prosecutorial function, is it wants to get, for example, Mr. Payne back from London. So it then makes the request, and the request will have to be transmitted, and that transmission is done via DIRCO. But in between the NPA and DIRCO is the Department of Justice. There are 3 people that work in that particular agency within the Department of Justice. 2 of the 3 of them deposed to affidavits before the High Court. One of them is Eddie Boertes, and the other one is Isak Gelderblom. They explain that they are conduits. They don't exercise any discretion. They don't make any decisions. What they do is they get the request from the NPA, and they've got a checklist. They then sit with that request, they measure it against the Act and they measure it against the treaty to see whether whether everything that needs to be in the request is there. They neither veto the request, they neither exercise any discretion in relation to it. The minister certainly plays no role at all. So it goes from that, from the office of those three people, their directorate, they act as a conduit and they get it through to DIRCO. And DIRCO then, of course, transmits it in a diplomatic bag. So Justice Theron, that was in response to one of your questions. Your second one was the role of DIRCO. DIRCO's role is really just to transmit the request, and it does that through diplomatic channels. There's a suggestion, however, that if anybody at an executive level has got an issue with an extradition request made by the NPA, then DIRCO's mandate is to oversee the way that our country manages its foreign relations with others. And so it would then be DIRCO who would raise an objection. I don't think it's a veto power. It's probably an objection. Somebody from DIRCO may well go to the NPA and say, you've requested this particular extradition, and perhaps they may want to discuss it because it may impact on our country's foreign relations with another state. But I don't think it's a veto power. I think the NPA have got the exclusive power. That was certainly as the matter had been couched in the initial application. And your final question, Justice Theron, is other prosecuting authorities in the world that make extradition requests. There's a list of them that we provided in the founding affidavit, and it's in paragraph 51 on page 254 of our record. I can give them to you now quickly. The examples are the UK, Eswatini, Denmark, Botswana, Namibia, the Netherlands, Israel, Brazil, France, Mozambique, South Korea. They're all there. In all of those states, the executive doesn't make the request. The request is made by the prosecuting authority. Just like in South Africa, it's made by the NPA. This is up until Schultz. So that would be an answer, hopefully, to those questions. So I was talking about the importance of retrospectivity, and I explained to you that that if the effect of the SCA judgment in Schultz is to operate with full retrospective effect, there will be a lot of disruption, a lot of work that will be lost, and in some cases, people that have now been secured who might escape. So there's an affidavit from Mr. Mgiba, Laksen Mgiba. This is his portfolio, and on page 464 of the record, he sets out a table, all of the extradition, the outgoing extradition requests that have been made, and he has a look at those requests made by the NPA that have already been acted upon. I think that means that the foreign state has now arrested those people, perhaps incarcerated them, or has convened an extradition hearing for them. He has another one where the extradition requests have been sent, but they haven't yet been acted upon. There's a third category where the extraditions have been finalized, but the trial hasn't happened yet. That would be people like Ms. Chaloto. And then finally, there's a section there where new requests have been submitted. In other words, following Schultz, what has happened? There are 8 of these matters where the minister has now made the request. Now, that can't happen all the time, so I see that Mr. Schultz latches onto that, and he says, well, what's the problem? He says it seems to be an easy thing. So the NPA did it the first time around, they weren't allowed to. It's the minister. Why can't the minister just correct matters? And the answer to that is to be found in a replying affidavit in the application to admit new evidence. And in that particular affidavit, a great deal of time is spent on explaining why it's not as simple as Mr. Schultz maybe says it is. When I talk about Mr. Schultz, I'm talking about his attorney who deposed to the affidavit on his behalf. And we find the reasons, I think, in paragraph 35. I beg your pardon, it's actually not in that replying affidavit. I beg your pardon, I just need to... is it there, David? Paragraph 35. Sorry, I beg your pardon, Justices. I'll just quickly find it. Here it is here. It is, in fact, paragraph 33.5 of my heads of argument. It's not in the record, but it does reference exactly what Mr. Simmons was referring me to now. And that is paragraph 19 of the record, 19 of the affidavit in page 529 of the record. And that explains, for example, that in the case of Payne, it wasn't a question of simply withdrawing the request and then giving it to the minister and saying, please won't you sign a covering letter. What had to happen there is every single witness had to be contacted, every affidavit had to be re-signed. In some instances, the UK authorities required that the affidavits be redrafted. Prison inspections had to be redone. Evidence from prison doctors and other prison officials had to be made. And of course, the Minister of Justice had to be briefed on the matter. You don't just make a request without knowing what the case is about. The Minister of Justice is a politician, not a prosecutor. It's difficult to find the time for this person and then to sit down and explain to this person what the case is all about. And that also took time. And because of the position in the UK, the NPA had 40 days to do this, and they only just made it, dedicating all of their resources to it. So it was categorized as a priority matter. If it's not a priority matter, it will never get this kind of attention. But because of the kind of criminal that Mr. Payne is alleged to be, it was much more important that they dedicated all of their resources to trying to renew this request for him. It's not possible in other cases. And that's the problem. So a lot of the 87 or 89 outgoing extradition requests could end up resulting in the NPA losing people and ultimately possibly not being able to run their criminal trials. One of the objections that Mr. Schultz raises to the admission of this new evidence is he says, well, there's no evidence before the High Court or the SCA about retrospectivity. That isn't a problem because as this court has held in a number of matters, we refer to 4 of them in paragraph 71 of our heads of argument. Cases like Mlungwane, NCGLE, Malachi, these are matters where there was no evidence either. And retrospectivity wasn't argued in any other court, but this court, Merimoto, said, we've got the power to look at this without any evidence. We can look at it afresh. In fact, we can even make a decision without any affidavits before us. And so for all of those reasons, you could do it here too, but you're in a much better position than you were in these previous cases. You're in a better position because you've got the evidence. You just have to admit it. But it's on affidavit and it explains what the positions are. I'm fairly mindful of the time ticking by, and perhaps the time can be more usefully served with you asking me questions. So before I get there, if I can just say one last point, and that is on the just and equitable relief, the section 172 1B stuff. In that regard, the evolution of how that remedy developed has been set out in our heads of argument. And of course, we're not talking about, so Mr. Schultz's objection is, well, in a declaration of law, you can't really have the retrospective effect being tempered because the guillotine comes down and says it's unlawful. That, of course, isn't correct. This court has done it many, many times and we give all the examples. But this is more than that. It's a case of conduct. It's unlawful conduct because somebody did something that they weren't empowered to do, so the argument goes. And in that instance, courts all across South Africa, every single day, in PAJA reviews, in constitutional reviews, in legality reviews, we often declare conduct to be invalid and unconstitutional, but we suspend the operation of that order, or else we make it prospective. And we've given examples of All Pay 1 and 2, Backslash, and 1 or 2 others. So that really, so we believe that this falls fairly squarely into that domain. And before I submit myself to questioning from the bench, what this court said in Mwalazi, you'll find it quoted in paragraph 97 of our heads. The court said that when we talk about just and equitable orders, it's effectively an invitation for the court to find a practical solution to a problem. So you've got a problem, It needs a practical solution. And this court's powers are relatively unfettered. It can do just about anything in order to solve the problem, provided that it's just and equitable. And that's been stated in a number of cases, and those are also cited in our heads of argument. So it's a problem-solving mechanism, or a remedial mechanism to solve a practical problem. And the practical problem here, of course, is that lots of years of work are going to be disturbed, lots of criminal trials are going to fall out the window, the reputation of the NPA is going to be harmed, South Africa's international reputation is going to be hurt, and a lot of people that should be on trial are going to end up walking free. So thank you, Justices, for allowing me that indulgence of 25 minutes. And I submit myself to you.
Thank you, Mr. Hopkins. I'm not sure, perhaps you can help me understand the context of your argument as presented to us. Your client comes here only on the retrospectivity issue. Am I understanding you correctly?
Yes, you are.
And you still sticking to that brief?
Yes, I am.
If I look at the SCA order,
yes.
Well, let's start with the facts. The application was before the extradition itself was requested, isn't it?
The application, yes,
Yes.
His extradition hasn't been requested.
It had not been done.
Yes.
So this was a futuristic looking application.
Yes.
And the SCA specifically said, when it made the declaration order, I'll find the paragraph now, that its decision will affect cases in future.
Paragraph 16.
Yeah.
Is the one you're looking for.
So, where does retrospectivity come in?
It comes in as follows. I don't think you could reasonably have the SCA giving a declarator that says, when it comes to Mr. Schultz, only the minister can ask for his extradition.
Yep.
But if this court upholds Mr. Trengove's argument on authority, then this court will say, but for everyone else in South Africa, it's the NPA. But for Mr. Schultz, it's the Minister of Justice. We can't have a situation like that. It's intolerable. This is a rule of law question. Somebody either has the power or they don't, as this court said in Chonko. So that would be my first answer to you, Deputy Chief Justice. My second answer to you would be that when you look at the SCA judgment, in paragraph 7, paragraphs 1 to 7, the SCA frames the declarator in narrow terms, much like Mr. Schultz wanted it. In other words, this is a declaration all about me, for who can request my extradition only in relation to America. But in paragraph 13 of the SCA's judgment, the SCA says, but the narrow framing of the declarator masks the real issue between the parties. And the real issue between the parties is who's got the power to make outgoing extradition requests from South Africa to any other state. Who's got the power? Is it the NPA or is it the Minister of Justice? So where we are is, you're absolutely right, Deputy Chief Justice. What you've got is you've got a declarator ultimately which looks like it only applies to Mr. Schultz. But in real life, when you start looking a bit more carefully, it's clear from the SCA's reasoning that the declarator was intended to apply to a far wider audience than just him. And in fact, I could tell you that Mr. Schultz himself knows that. So, for example, there's a conflict in his papers, which I can draw your attention to quickly. It's what he does is in paragraph 38 of his attorney's affidavit. It's on page 380 of the record. Mr. Schultz says the SCA's order only applies to me. It doesn't bind anybody else. It's only binding on me, and that's why there can be no question of retrospectivity. He says that, as I say, para 38 on page 380. But then, when we deal with the new evidence, and we deal with this request of Caro and Perez, the guys in Spain, then all of a sudden what Mr. Schultz now says, he contradicts himself. And we find this in paragraph 10.2 on page 489 of the record. Now he says the NPA acts in willful defiance of the SCA by requesting the extradition of Mr. Caro and Mr. Perez. In other words, how dare the NPA request their extradition? Because the SCA says it doesn't have the power. So on the one hand, his argument is it only applies to me. On the other hand, he says it clearly applies to everybody, even Caro and Perez, even Spain. So I don't think the declarator is as narrow as that, Deputy Chief Justice, if I've answered your question.
Okay. Well, perhaps my colleague will take it further, but I just thought, let me clarify that, because I've read it. It says, further, the appeal raises an important legal issue which will affect extradition requests in the future. So I'm trying to find, on what basis can someone say, no, something that happened 10 years before Schultz can now be undone on the basis of this judgment?
Well, it shouldn't be, and that's why we don't want it to apply with full retrospective effect. But if it's, remember, this is an ultra vires question. So if it's an ultra vires question, the question is who's got the power? And if the person without the power purported to exercise the power that they don't have, then people can do exactly what Mr. Payne did and exactly what Mr. Caro and Mr. Perez did. They can come to court here. Caro and Perez went to Joburg, and Payne went to Pretoria, and they wanted to review and set aside the extradition requests made by the NPA on the basis that they were ultra vires. And that can happen in relation to every single other person. Whether they'll come right or not is a different question, but how much time and resources, judicial resources, will be spent defending all of these reviews? So for that reason, just again, for practical reasons, to solve a practical problem, tempering the order of retrospectivity would go a long way to assisting.
Thank you, Ms. Hopkins.
It's me, Mr. Hopkins. My problem, in fact, it's a predicament that I have, is us deciding on the retrospectivity issue in a vacuum and without any information that is not disputed. For instance, the issue around, I think it's Mr. Payne, when it is said that, in fact, it was through the involvement of one of the legal representatives that the true picture became clearer to us. Maybe it's somebody else, but it's one of the cases you've referred to. And I'm saying, as I'm sitting here talking to you, I don't know what case would need us to make the declarator retrospective and on what basis. I'm sitting here not knowing, how that kind of order impacts on other cases that you fear will be impacted, and what those cases are, and what the specific case effects of those cases.
Justice Chiki, perhaps I can refer you, we can have a look at the heads of argument because they will refer to the record where we try and address the problem that's concerning you at the moment. So in paragraph 32, for example, of the heads, what we do is we start to look at some of the matters. So there's obviously Mr. Schultz's own matter, but to get away from that, we've got Mr. Payne's matter. Now, Mr. Payne, the extradition request for Mr. Payne was made before Schultz. Mr. Payne then came to Pretoria and applied to review and set aside the extradition request. He was already sitting in Wandsworth Prison in London. He's sitting in prison. He had been declared extraditable. He was busy appealing that, but ultimately he was on his way back to South Africa to stand trial. But then what happens is he brings the review in the Pretoria High Court, and ultimately Kilmartin AJ, whose judgment is part of the papers, says, well, I'm bound by the SCA judgment in Schultz. And the SCA judgment in Schultz says that the NPA can't request Mr. Payne's extradition. That request is invalid. In the end, what Mr. Payne does is he then takes that judgment with him to London and brings an application in London as well, and ultimately is released. He is released. As I've demonstrated, there is a new extradition request signed by the minister for him. But what happened is the King's Bench on appeal ultimately said that there was an abuse of process by the South Africans, not in the sense that we understand it, but in the sense of an ultra vires act, which is how they understand the term. And the ultra vires act is just the wrong.
Was the release solely based on Schultz, on the order in? Solely
based on Schultz, on nothing else. Only on Schultz. Now that is the one matter. We've got Charlotta's, the second one. That's been ventilated now. We know that her release, at the end she said, you can go now. That was also based squarely on Schultz and on nothing else. But there are other matters. So I've mentioned Cairo.
So you're saying there are other matters. So we would not be discussing in a vacuum.
Judge Chiki, you wouldn't be. There's a whole table of 87 matters.
No. This is where I'm going. You're saying that there are those matters. In the papers, just give me the pages where the specifics of those matters are outlined so that I can then look at them.
Okay, so to start off with, in relation to Schultz himself, that's dealt with paragraph 5 on page 8 of the record. We don't need to worry too much about that. Mr. Payne, so all of the my lady, Justice Chiki, what might be easiest for you, because all the references are there with the cases, is in paragraph 32 of our heads of argument. We identify the case and we footnote it with a page in the record to where you can have a look at the new evidence.
And all the specifics of those cases.
Yeah, and all the specifics. So let me give you an example where there's some more detail on the new evidence. That you will find in the application to admit the new evidence, which is in volume 4 on page 408. So volume 4, page 408, we deal with the new evidence in paragraph 57 onward. Let me just have a look at this. Sorry, that's just the actual application for the new evidence. The actual detail that you're looking for starts in paragraph 7 onwards on page 395. And so, for example, paragraph 13 of that affidavit on page 396 deals with how it was anticipated that this would all happen. That's paragraph 13. Paragraphs 14 and 15 show how it actually did end up happening roughly as predicted. And you will find the names of the cases in paragraph 15. And then there's some detail about Richard Payne's matter in paragraphs 16 to 20. Charlotta in paragraphs 21 to 28. The Ndamandi brothers, you'll see paragraphs 29 all the way through to 34. Elia Mokotwana.
Yes. I now recall having seen those examples. Are they not disputed?
No, they're not. What happened is a table was given by Mr. Lakshman Mgiba. That table is on page 464 of the record, in which he laid out every outgoing request and at what stage each request was, who the person was, to what state the request was made, and at what stage of the proceedings we were at. And in that matter, Mr. Schultz came back and he said, well, hang on a minute, you've made one mistake here. He said, you've referred to a chap called Benjamin May. And you said you've referred to Benjamin May as being an outgoing extradition request.
Yes, that's the matter where it was said that you misrepresented.
And well, they said we made a mistake. So what we did is we came back and said, yes, we actually did make a mistake. We gave the details of May. We said it was a mistake we made, and we said we've now gone back and checked the other 86, and we're happy that a similar mistake hasn't been made, and that was never disputed. But a lot of this is also reported. So a lot of these documents, for example, have also been attached, and you find them in the record. So if there is a dispute that comes from Mr. Schultz, it's not a genuine dispute. It might be a dispute of one or two things. For example, as we say in our heads of argument, he might be disputing that there are 87 outgoing requests. He might say, no, there's not 87, there's 77, or 67, or 57. It doesn't matter. The point is there are outgoing extradition requests. And facts in relation to those are not being disputed, and they will be disturbed with devastating consequences if retrospectivity hasn't been tempered, or isn't tempered.
Okay, thank you for that. And thank you for referring me to the pages of the records. And now recall that there are cases that you've referred to specifically. Whether that's specific enough or it has sufficient details for us, I'm going to look at it. I can't recall now, but let's deal with another matter.
Justice Chiki, can I, before we leave this point, what is really helpful is in those paragraphs in Volume 4 that I referred you to, what there are is their annexures. So when, for example, one talks about Cairo and Perez being affected, we don't just say Cairo and Perez are being affected. One of the annexures then to the affidavit is their application to the Joburg High Court. And you can see from the application that they want to review and set aside their request because it was made by the NPA. We attach the King's Bench judgment and the judgment of Kilmartin so you can see how Payne's extradition request was set aside and he was effectively released, but for a provisional arrest warrant for something else that he did wrong. But the impact is all there. The evidence of how it happened is there. And I don't think that is seriously contested. So there might be little bones of contention here and there, but fundamentally it doesn't change the impact that Schultz will have if it's not tempered.
The second question that needs clarification on is how is just the issue of retrospectivity, bearing in mind that it's on the remedy. But even on the remedy, it's a narrow issue, just the retrospective effect of that order.
Yes.
How is it a constitutional matter?
How is it a constitutional matter? Well, so this is a jurisdiction point that has been taken by Mr. Schultz. What happens initially when we were going for both remedy and merits, it was easy to see the constitutional issue. When it became only about the remedy, what is happening with remedy is we are effectively disrupting the functioning of the criminal justice system. We are disrupting the administration of justice itself. These are all constitutional issues. So they are not suddenly unplugged from the Constitution. They are very much, because the proper administration of justice is always a constitutional issue. That's the one point. But the second point is that, and I think the case is Hoërskool Ermelo that was dealt with by this court, where the court said that issues of remedy can be dislocated from constitutional issues. In other words, 172(1)(b) can be triggered even without a declaration of invalidity. But here we do have one. And on that point, Justice Chiki, what I understand Mr. Schultz to also say is, well, you don't really have a problem with any order. You're not appealing an order. But that isn't correct. We do have a problem. We've got a problem with the order that says that the declaration of invalidity applies with full retrospective effect. That's exactly the problem that we have, and that's exactly what we're appealing against. And of course, this is all conditional only on you rejecting Mr. Trengo's argument on authority.
Well, thank you. I was wondering whether it's probably a matter that falls within the general jurisdiction of Constitution. The reason why I looked at general jurisdiction, because I thought that maybe it could be argued that it's a matter of general public importance.
It could be argued there as well. In fact, it has been argued like that in our paper. So we came in the alternative. On the one hand, we said it's connected to a constitutional matter, and in relation to remedy, that plugs only into administration of justice. But on the other hand, we said it's also an arguable point of law of general public importance, and there we spoke about the fact that the point of law is arguable, but most importantly, the public importance are the same reasons that would trigger this court's jurisdiction in relation to whether it's in the interest of justice that the matter be heard at all. In other words, again, to preserve the good work that the NPA is doing without unraveling the whole system and undermining the efforts that they have in relation to crime fighting.
And you're saying in response to the CJ, we should not worry ourselves about the fact that it was not raised in the SCA. But we must pay attention to the fact that this court does have jurisdiction.
Yes, perhaps I can, what may...
Even if they were not raised at SCA or High Court.
Yes, Justice Chiki, if perhaps I could assist you with the cases that you may be interested in that regard. You'll find them in paragraph 71 of our heads of argument.
Yes, no, I'm not disputing that this court has dealt with matters that arise in this court for the first time, but there's qualifications to it, and I'm saying that you are arguing that we should not pay attention to the fact that it was not raised at all in the High Court and at the SCA.
Justice Chiki, I don't think so. I mean, part of the reason it obviously wasn't raised I don't know for a fact why it wasn't raised in the SCA, because but it might well be because the NPA was successful in the High Court and it slipped their minds and they didn't deal with it then. But it's not an impediment now. But as I say, I mean, and really this is the central submission that I can make to you on this point, is that in all of the cases that we've cited where where this court was inclined to temper retrospectivity without affidavits and without evidence, that's one thing. But you're in a much better position here because we've tendered the evidence. We've got the affidavits. All you need to do is to admit them. And then you've got everything that you need to see exactly how devastating it will be if the order isn't made prospective.
Thank you, Mr. Chair.
Mr. Hopkins, do you have authority for the submission that matters concerning the administration of justice is a constitutional issue?
I don't have authority, but I've got section 165(4) of the Constitution. And that section says that organs of state through legislative and other measures must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. So that would be the work of the courts when it comes to criminal matters, in, I suppose, doing the work of the criminal justice system.
It's very different from the work of the NPA.
Beg your pardon, my lady?
And the work of the courts is different from the work of the NPA. We're dealing now with the work of the NPA.
Well, the work of the NPA is to get criminal matters in court and to prosecute people, but for that you need a trial. But the ability to get them into court and to have a trial is going to be impeded if they're released because the order is retrospective.
Where is that dealt with in the papers?
Okay, it's dealt with in two different sets of affidavits. The very first one you'll find in volume 3 on page 236. And this is the DPP's affidavit, Mr. Chake's affidavit. And let me get you the exact provisions. Paragraphs 38 to 47. So paragraphs 38 to 47 you'll find on page 249 of the record. And Justice Theron, perhaps I can read it to you, because it taps in, and the wording is used that we're talking about now. So paragraph 38 says, the effect of the SCA's judgment is that the historical process for outgoing requests will be invalidated, we know that. Paragraph 39, we talk about the far-reaching consequences for numerous outgoing extradition requests. Paragraph 40, we talk about the 89 of them that fall to be set aside. Paragraph 41, we talk about the amount of time and effort that goes into preparing each one of these. Paragraph 42, we talk about the domino effect, and we highlight it with reference to Payne. Paragraph 43, we have a look at Payne's entire case is based on Schultz. Paragraph 44, we talk about the consequences for the NPA if pain is released, but the one that you're really looking for, I think, is paragraph 46. Because 46.1 talks about the chilling effect on the administration of justice. It talks about the chilling effect on the country's criminal justice system. It talks about the blow to the public's confidence in justice and legal system. It talks about the trust of foreign states. It talks about us being downgraded when it comes to crimes like money laundering. And this, I said to you there are two affidavits. This is the one that happened before. We were still anticipating what may happen. In the new evidence, we then show how everything that we predicted did happen. In fact, we even attach media reports where journalists are saying how people have lost confidence, how foreign states are losing confidence. And those media reports have also been attached to our paper. So what was anticipated, unfortunately, seems to have materialized.
I still have a concern, Mr. Hopkins, that how does the loss of, let's call it, hours or work hours or man hours that might be caused to the NPA
Yes.
as a result of the Schultz judgment
Yes.
render this matter a constitutional matter? You must remember the decision concerned who makes the decision regarding extradition.
Yes.
Is that a constitutional matter?
Absolutely. It's an ultra-virus question. It implicates the rule of law. It's a Section 1C matter. It's always it is unquestionably not a constitutional matter. But your question was slightly different. You said in relation to remedy. So the rule of law stuff is clear. The remedy stuff, it's a little bit less direct because you've got to have a look at it through the damage being done to the criminal justice system. It's not, and Justice Theron, I don't think it's only harm to the NPA. It's not only going to the prosecutors that have been working for 10 years and saying to them, well, sorry, your case is crumbling, the accused is gone, you won't have a trial. It's not that. I mean, sure, that hurts the NPA, but it's what it does to the country and the way that our courts function and the way that our criminal justice system needs to work.
Well, it seems to me that what it might do to the country is people might lose confidence in the NPA. That the NPA is put in all these wasted hours, they don't quite know what they're doing.
So-
I don't see how that directly affects the administration of justice, making this a constitutional matter.
So what may help is volume 5, page 469 onward. So these are media articles. Now, media articles aren't evidence, but what they are is a fairly reliable statement of how people that are keeping tabs on things see the damage that is being done. And the very first article is the Business Day article. It talks about a crisis of confidence in SA justice. And yes, some of that is criticism directed to the NPA. The second article comes on page 473. That says the NPA's series of legal bundles undermines confidence in the legal justice system. So your concern is it hurts the NPA, but how does it possibly hurt the criminal justice system or the administration of justice? This article usefully ties them together.
Opinions, Mr. Hopkins. Whether or not this court has jurisdiction and whether or not this is a constitutional matter, I don't think we should be relying on newspaper reports.
No, we're not. No, the newspaper reports are evidence that what was anticipated is happening. We anticipated that people would say the administration of justice and the criminal justice system is not working. We anticipated that would happen, and it did happen. So that is only evidence to show that it's not an abstract fear.
It's showing people's opinion.
Yeah, and the reputation of the way the criminal justice system functions is important, because that's what the administration of justice is.
I'm not entirely convinced, but I speak for myself. And what might rescue this matter is that it links to Chilota. What might rescue this matter is that it's linked to Chilota.
Yes, it might.
And it might be in the interest of justice to hear the two together. I have another concern.
Before we leave the topic, Mr. Simmons?
I'm happy with that, Mr. Hopkins. judgments.
You're not happy with it?
I said, I'm happy.
Are you? Because Mr. Simons has given me a case. And in fact, it's a judgment of this court. Justice Majid wrote the... Ron Simpiwe Mkwabe. And what I've been asked to just have a look at here is paragraph 1, which says the following. This court has repeatedly emphasized the important role occupied by the NPA in the administration of justice in our young democracy. Axiomatically, the leadership of the NPA at both national and provincial level is crucial in fulfilling this important role. So that links the proper functioning of the NPA and its ability to do its work with the administration of justice in the Constitution.
I'm still not sure, but we can go on the basis. I'm prepared to accept that perhaps linking it to Chilota might get you a foot in the door. Is the applicant relying on this court's power in 172 in respect of retrospectivity and any order it might make?
Yes, it is.
Let's look at section 172. When deciding a constitutional matter, a court must declare any law or conduct that is inconsistent with the Constitution invalid. Did the SCA make a declaration that any law or conduct...
It did not.
Do we then get to 172 in retrospectivity if there is no order of invalidity? Because usually retrospectivity is coupled to an order of invalidity.
Yes. So Justice Theron, I think that is Mr. Schultz's argument as well, similar to yours. The answer to that, I just need to get you the judgment, and I'll tell you where it's dealt with in our heads of argument. Also, a decision of this court which uncouples the two concepts. So it says you can go to 172.1b without going through 172.1a, but I need to get that for you. I beg your pardon, I'll just... It's the Hoërskool Ermelo judgment that I referred to a little while ago, and thank you. And it's in paragraph 97 of that judgment. So it's a judgment of this court.
Repeat for me, which judgment is it?
It's called Head of Department and Mpumalanga Department of Education versus Hoërskool Ermelo. And the citation is 2010, volume...
I think I'm familiar.